Hello, 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 and welcome. Welcome to you all to a Tuesday night live stream. Please excuse me for being late. My name is Natalie. I'm a criminal defense attorney, and tonight we are going to be dealing with a case that is very um, serious, I would say, deals with a lot of issues that we all interact with and interacts with both the law and mental health, the law and medicine, the law and family dynamics. And so I wanted to talk to you guys about this case because so many of you asked for it. So yesterday I was kind of struggling with what to do. And you guys said, take care of Maya. And I said, what's that? And I immediately started researching and I said, wow, this is going to take more than just to let me react to some video real quick. This is going to take some serious research. So I did that research. And I am also kindly joined by our co host and guest, Dr. Patrice Berry. Hello, Dr. Berry.
Hello, hello.
Hello, it's so lovely to see you. Just give me 1 second. Guys, right now there are 215 of you in this live stream at 1 minute and 20 seconds in. That is amazing. Please make sure that you like the video. That way more people can know that we are currently live. We are also being joined by people from Dr. Patrice Berry's channel. If I understand that correctly. Do you have a name for
Yes.
your subscribers, Dr. Berry?
And so it's just a crew. So we have a psych crew.
The Psych Crew, I love it. So, hello, Psych Crew. Welcome. I hope that the Lawyer Chicklets are being great co hosts to you. We're all a wonderful community here together. So, if you guys could please be so kind as to take your shoes off, get comfortable, and like the video, and also go and subscribe to our guest, Dr. Patrice Berry. And like I said, also co host because we're co streaming on Dr. Berry's channel as well. So if you are, a subscriber of Dr. Berry and you're interested in legal take, come over here. And if you're interested in a doctor's take, go over there. So thank you all so much. You know what? That was a good question. Someone was like, is there a link? There will be. 1 second. We're going to make sure that happens right now. That should have been the first of mine for me, but you know how it goes. Here is Dr. Patrice Berry's channel. There are too many tabs open. Okay. All right. So the link is now in the chat. I'll also make sure the link is in the description box for those of you that are watching it here on the replay crew. Hey, Matt Bond, so nice to see you, my friend. Hope that you're doing well. I usually like to wait for, sometimes I get people, Dr. Berry, that come in and complain, oh my God, you take so long to get to it. Child, we're waiting for people to get here. Okay. We did the research. We're doing the work. We've got our expertise. We want you guys to be able to see it for those of you that want to see it live. So look that just sub to you. Thank you, Lisa Boo. Thank you.
Thank you. Thank you. I appreciate it.
So look, everything I'm asking for you guys to do today is free. Like the video, subscribe to this channel, subscribe to Dr. Berry. You guys liking the video already got us up to 300 people in this live stream at 3 minutes and 40 seconds into the stream. That is amazing. You know why I have the smooth jazz voice going on? Because I have both of these things in and I cannot hear myself. Does that change your voice? Like when you can't hear yourself? Like that makes me speak weird.
So sometimes people speak louder, but it sounds
Mhm.
like you speak softer because
I do.
it was super chill. Like it was
I
super
do.
chill.
I
Yeah.
definitely do. When I have headphones in and music playing, people always say, "Why are you talking softer?" And I'm just like, "I don't know. I just I feel like I can feel my voice or something. I don't know." All right. So, Jazz is here at my feet. It's a little later in the evening, and Homegirl and I went on a 3-mile walk today. So let's hope that she'll be tuckered out and tired. If not, her dad's gonna have to come and get her, but she's in here. All right, guys. Listen, we're not going to be doing a format where we're watching all of the trial. I picked out
Yeah.
parts. I also did some research, and I would like for Dr. Berry to also please give me her insights and give me whatever parts she wants to look at. So this is going to be a breakdown of a good chunk of the trial up until now, with selected pieces so that we can get it kind of like an overview. So, Dr. Berry, if it's okay with you, unless there's something you want to say at the outset, I'm going to get started on the slideshow that I prepared for you guys. And then obviously you guys can chime in with any like corrections or takes or anything like that that you may have. That's not where I wanted to start. So let's get back to where I wanted to start. Hold on.
And let me just say, so I'm a licensed psychologist,
Yes,
and
please.
with this, because there's a diagnosis that comes up in this case,
Sure.
and so that's why anytime I talk about a case, there's always a psychological perspective or aspect,
Sure.
and I'm
Mhm.
glad that we got to collaborate on this one.
I am so excited for this. And for those of you that don't know, and maybe this is your first time viewing the channel, I'm a criminal defense attorney. So I used to, at one point in time, handle civil cases. I have also been a litigant in civil cases, so I'm very familiar with them, but I am not an expert on civil law by any means whatsoever. But I do bring a legal perspective, and especially a defense perspective when looking at these things. So that's why I thought that this would be very interesting for the both of us to discuss. So let's get this started. So we're going to be talking about the Take Care of Maya case, which is Kowalski versus Johns Hopkins. It was Johns Hopkins and a bunch of other defendants, but those defendants have dropped out for various reasons, which we'll talk about here. So I did prepare a disclaimer, Dr. Berry. I thought that this would be helpful, just given the nature of the case. We're going to be having some very serious discussions today. So I'm a lawyer. This is not legal advice. No action should be taken in any legal case or issue in reliance on the information that I'm providing in this video. This is solely based on my personal and professional opinion without having any legal relationship whatsoever to any of the parties in this case. Dr. Berry is a doctor, but this is not medical advice. No treatment or medical decisions should be made in reliance on any of the information provided in this video. If any of these issues trigger something for you, definitely seek the help of a medical professional who knows you and is treating you. All statements are those of opinion unless otherwise agreed to by the parties or decided by the jury or the judge, I should say. This case concerns discussions of self-harm, the illness of children, and traumatic events. Do not watch this video if you are sensitive to these subjects. I already saw some people in the chat saying this is not for them, and not a problem at all, because I completely forgot to do the Nicki Minaj versus Cardi B and their husband's beef video. And I'm definitely going to do that because that does have a legal component and nobody died. And, so just save yourself for that video. That video will be more fun. If you or someone see, Natalie, if you or someone you love you are struggling, or they are struggling with thoughts of self-harm, the Self-Harm Prevention Lifeline in the United States, you can just now dial the number 988, just like how you would dial 911, and that will take you directly there. Or in the United States, you can dial the number 1-800-273-8255. That's 1-800-273-TALK. We will be dealing with discussions such as that. So if this triggers anything like that for you, please do seek out help at any time. And there's no shame in asking for assistance when you need it. Okay, so I'm sorry, I just rambled a bunch of stuff. Is there anything you want to say in relation to what I just said?
And so the 988 number, you can also text message that phone number, which I think is great because some people, especially, so I work a lot with teens, and often they don't want to call. They don't call people. And so that number, you can message it. There are some situations, I like to give the caveat. So it is supposed to be anonymous and all of that. And some people have good and bad experiences. Over on my page, I also have some resources if you're looking to find a therapist, like psychologytoday.com and a few other resources there.
Wonderful. Thank you so much, Dr. Berry. Okay, so the plaintiffs in this case, this is a civil lawsuit, and the plaintiffs in this case are the dad, Jack Kowalski. So just some background on him. He previously worked as a deputy fire chief at Elmhurst Broadview Fire Department. He retired from his job in order to spend more quality time with his wife and children. And after his retirement, he, along with his loved ones, relocated to Venice, Florida to start a new life. The facts of this case all arise out of Venice, Florida. The mother in this family is Beata Kowalski. And Beata was an immigrant from Poland who worked as a registered nurse. She was accused of abusing her daughter, Maya, due to Munchausen syndrome by proxy, which we're going to be getting to in detail with that, Dr. Berry. They said that she faked symptoms and created real symptoms in order for her child to appear injured or ill. When the investigation began, she was ordered by the court to undergo a psychological evaluation. The results of the evaluation stated that Beata was not suffering from mental illness. Kyle Kowalski is the youngest member of the household. He was born in 2008. He is 15 years old. They are 2 years apart from each other. So for everything that was happening, Kyle is 2 years younger than Maya. Maya Kowalski is basically the main plaintiff and subject of this entire case, controversy, and lawsuit. In 2015, she was diagnosed with CPRS, a condition with chronic pain that often affects the arms and legs. When she was 9 years old, she began experiencing headaches and asthma attacks. After some time, lesions began forming on her arms and legs and also her feet, with curling and cramping of her feet. Later, Dr. Anthony Kirkpatrick identified her symptoms for CPRS and treated the disease with infusions of ketamine, which became highly controversial. These are the defendants in the case. Throughout the life of this case, we're now down to just Johns Hopkins. So Johns Hopkins All Children's Hospital is the hospital in Florida where Maya was admitted for severe pain. Dr. Sally Smith, MD, is a pediatric doctor who was employed by Department of Children and Family Services, Suncoast, and she settled the case for $2.5 million. Catherine Beatty, I think it's Beatty, is a social worker. She was dropped from the case on the third day of jury selection. And then DCF Suncoast Center is a private corporation that provides evaluation to Department of Children and Family Services in Florida, and they were a part of the $2.5 million settlement. That settlement was reported by a website or an online journal called The Cut, who did a Freedom of Information Act request in order to find out what happened to the other litigants in the case. So Catherine Beatty was in the case right up until the very last second when jury selection began, and then they allowed her to walk away. That's what the plaintiff said, the plaintiff's attorney. So at issue here are two main disorders. There's other disorders that come up of mental and physical, of a mental health and physical health nature, but the two that are the most important are complex regional pain syndrome and Munchausen by proxy disorder, or factitious disorder imposed upon another. So CRPS, or complex regional pain syndrome, is a form of chronic pain that usually affects an arm, a leg. It typically develops after an injury, a surgery, a stroke, or a heart attack. The pain is out of proportion to the severity of the initial injury. It is uncommon, and its cause is not clearly understood. Treatment is most effective when started early. In such cases, improvement, even remission, are possible. Dr. Berry, anything so far?
Yes. And so with CRPS, so I watched the Netflix documentary, and the
Sure.
specialist in that case talked about the fact that it's common
Mhm.
in girls. So, like, when it is diagnosed, it's
Mhm.
sometimes between the ages of 9 to 11 that it can present around that time, but it
Mhm.
is extremely rare.
Mhm.
And so we're going to dive into where some things could have went different for this case
Mhm.
to have a different outcome.
I really would love your perspective on that, because I'm still diving into the facts of this case, and I'm really going off of the testimony so far. The testimony has not concluded, and so I would love your perspective on that. All right, so the next disorder, symptoms of CRPS include continuous burning or throbbing pain, usually in the arm, leg, hand, or foot, sensitivity to touch or cold, swelling of the painful area, changes in skin temperature, alternating between sweaty and cold, changes in skin color, changes in skin texture, changes in hair and nail growth, joint stiffness, swelling and damage, muscle spasms, tremors and weakness, atrophy, decreased ability to move the affected body part. And this is not me doing like a medical thing at all, because not in my wheelhouse. But it reminded me, because my understanding is that's a neurological disorder. It reminded me of my migraine disorder that I have. So I have a chronic migraine disorder. And I couldn't believe that it was migraines, because at first I was like, migraine is just a headache. What are you talking about? But the neurological component is that when I'm having a migraine, light hurts, and light physical touch is extremely exponentially painful, just because your nervous system is just out of whack, acting crazy, whatever the reason may be for it. And just light touch. So every time they brought that up, I was like, anytime there's something neurological going on, I completely I can see how that can happen now, whereas I couldn't have seen how that could happen before.
Yeah.
So go ahead.
And they talked about how the ketamine, it was meant to kind of reset the brain. That sometimes, and I've heard other people talk about the pain center of the brain getting switched to on, and that like the ketamine, that it would reset things so that the individual wouldn't experience that severe pain ongoing like that. So the point of like physical, like she wasn't able to walk, like all of those different things were going on.
Yeah. That again, if anyone here suffers from anything neurological or chronic, you understand. I've had my doctor tell me, like, I get pre-migraine auras, right? And my doctor says, even if you're not experiencing pain during the aura, take your medicine now, because it's like your body learns how to be in pain. Like it gets in like this pain loop, you got to try to interrupt it as quickly as possible. So all of that makes sense to me. So Munchausen by proxy is what Beata Kowalski was accused of having. And that's a psychological disorder. Okay, that's the WebMD version, but I would prefer it, Dr. Berry, if you would talk about it.
Yes.
Yeah, so while I have this up here, you guys can read it, but hear it from an actual doctor.
And so within the DSM-5, they actually changed the diagnosis. So this is what they call it in court, or sometimes CPS will call it this, or sometimes doctors that haven't looked at the updated codes, because it's called fictitious disorder by proxy. And same thing, but where it's a psychological condition where a caregiver is seeking attention for themselves through their child. And so they might do things like give them something that physically makes them sick, or they might alter test results or provide false symptoms, because for children, doctors rely on the adults usually to say, hey, what's going on?
Right.
And a good doctor, does their own thorough evaluation and all of that, and you would typically get an understanding of their history. But individuals with that type of with a Munchausen, they will often go to 5 different cardiologists and 3 different endocrinologists, and the child ends up being subjected to excessive testing and treatments that they don't meet criteria for. And often, sometimes it's also considered to be medical neglect, because there's a medical neglect where a child isn't provided treatment that they urgently needed, and then there's medical neglect where they're being provided way too much care that they didn't actually need.
I mean, the actual disorder is terrifying, and this is probably set in our culture forever as, kind of a specter because of what was it called? The Sixth Sense. Remember that? Yeah. Where one of the little girls passed away because of, and the ghost of the child was seen because her mother or stepmother was secretly poisoning her or whatever. Yeah. So that's actually just like a part of our popular culture, as well as something that we understand in the medical literature. So I'm going to go through the timeline of events. Dr. Berry, please do me a favor and just anytime, because I can't see you while I'm looking at the timeline. So just interject anytime. Please don't be overly friendly, cautious, polite. Yeah, just say what you need to say, please. So July of 2015, Maya, then 9 years old, suffered from a severe asthma attack and was admitted to JHACH. And again, like I said at the outset, that everything that I'm saying is alleged unless admitted to by both of the parties or decided by the judge or the jury. And so a lot of my facts I took from watching the trial itself and the actual complaint. And so there is a defense perspective here. So keep that in mind. During her stay, Maya began exhibiting severe pain manifestation and significant weakness, potential diagnosis of steroid-induced myopathy. So they basically, at her first stay at the Johns Hopkins All Children's Hospital, they said maybe she has steroid-induced myopathy from taking steroids for her asthma. So Maya was referred by this hospital to Dr. Anthony Kirkpatrick, a leading international expert in the treatment of complex regional pain syndrome. On or about September 23rd, 2015, Dr. Kirkpatrick diagnosed Maya with that disorder. And then other experts in the hospital system, JHACH, they confirmed the diagnosis. So on December 7th of 2015, a Johns Hopkins endocrinologist who saw Maya for adrenal insufficiency noted that Maya had lesions consistent with CRPS manifesting at that time. The reason I put an endocrinologist here is because in the complaint, the endocrinologist's name was redacted from the complaint, but it was redacted by agreement that the endocrinologist had actually seen these things and had reported it. So both sides agree on this, that these manifestations had been seen at the time. They give when I put TX, that's just short form for treatment. So ketamine is a treatment that's given, including a ketamine coma that she's put in Mexico. We'll get into that more. And this also requires follow-up care. So March of 2016, this is pretty major, I think. JHACH places a port in Maya to facilitate the ketamine injections. Remember that Beata is a nurse who a part of her was doing infusion therapy as a part of her being a nurse. Now, parents don't treat children like they're not supposed to do that, right? Yeah. That's not what they're supposed to do. But the same hospital that is alleging that mom is overstepping and overtreating her daughter put a port in her so that she could receive those injections at home. So at the time, they believed that this was appropriate care. Dr. Berry, anything you wanted to put in there?
So nothing to add at this point. I wasn't aware of some of the prior, because that didn't come up in some of the stuff. You did a much deeper dive than I did. Yes.
Yeah, it's I think it's going to come up in the trial, but they did not. This is not a factor that was gotten into until I think so this complaint is like the 8th amended complaint, and a lot of discovery has happened by the time this amended complaint is written. And so comparing this complaint to the first complaint that was written, it seems like they found out more through discovery that they didn't know initially, which was like, for example, them authorizing the ketamine treatment to Maya. So May of 2016, JHACH pulmonologist sent a note to Maya's pediatrician, Dr. John Wassenaar, and noted the significant improvement in Maya's condition and pain levels after having undergone the therapies for her CRPS. So remember, we are not even there yet in the trial. They have more people to come and testify. Everything you've heard so far is really just a buildup. Maya would experience intermittent flare-ups with the CRPS. It was controlled but not cured by the ketamine treatment. In October of 2016, after the frequency of her ketamine infusion therapies increased, Maya began experiencing reoccurrence of abdominal pain and vomiting, which we will hear testimony from the defense side could be a potential side effect of ketamine usage, especially an inappropriate amount of ketamine usage for a child. October 7th of 2016, Jack Kowalski, the dad, takes Maya to the hospital for treatment of these symptoms. Beata later arrived at the hospital and explained Maya's condition as best as she could as best as she could as a qualification from the plaintiff's attorneys. Let's just say, explain the condition to the ER staff unfamiliar with Maya's condition of CRPS. So she's been treated there, and they've concurred with her diagnosis, but she's coming into the emergency room, which is not the same as like in the internal care doctors or the neurologists or the pediatricians. She's just going straight to emergency. So you will hear a testimony in the trial about how they perceive Beata to be combative and pushy and rude and things like that. So this initial ER visit, I think, is a big turning point for this entire case, because they're not coming in for, like a consult or something like that, or with a regular appointment. Go ahead, Dr. Berry.
And so Beata is Polish. and she
Mm-hmm.
moved to the US when she was 16 years old. So
Mm-hmm.
I lived in Germany, and in that part of Europe, having a direct communication style is common. And I think she was very knowledgeable about her child's condition.
Mm-hmm.
She was pretty much saying, hey, this is what my child needs. And I think culturally, within her culture, that was common. Now,
Yeah.
she was in the South, and
Mm-hmm.
in a place where you have to be like nice mean, where you kind of have to be a little passive aggressive, or
Yeah.
I don't know, like she was in a place that I think she was coming across rude and demanding to them.
Mm-hmm.
But I
Mm-hmm.
think she was a mom who was
Mm-hmm.
concerned about the treatment of her daughter, and feeling like she's dealing with people that, like, because these individuals were not experts, they did not know about her condition. And so I think that kind of started some of the, where they're thinking mom has an issue. And the
Right.
fact of how they would describe it as pushy, but I would
Mm-hmm.
describe it as a cultural, like she's just very direct.
Yeah.
And she has no problem if she thinks you're wrong. She doesn't care that you're the doctor. She doesn't care who
Mm-hmm.
you are. Like,
Mm-hmm.
she is going to say how she thinks and feels.
Yeah. I think that could, I'm from New York.
Yeah.
There's a large Eastern European population where I'm from. Especially my junior high school that I went to. There were a lot of people from Czechoslovakia, Poland, places like that. And I know that can be true, but I also have a family member, my mother, who has a chronic condition
Yeah.
and is a stroke patient. And last year we had a very severe, what later on they finally confirmed was a secondary stroke, like a breakaway stroke, or, however you want to put it. However, we had a terrible experience with the hospital because they thought that we were exaggerating. They thought that we were being disrespectful. I asked for my mother to be discharged from that hospital and go to the hospital where she was originally treated for her stroke, and they refused her discharge. They refused her transfer. Let me put it that way. They refused to even request the transfer. We had to have the social worker in the hospital get involved because the doctor became like almost physically combative with us. We had to film him. It was a very traumatic experience. And unfortunately, I had to do the thing where I was like, I'm a lawyer and I know that this is wrong. And I don't ever like doing that, but I was concerned for my mother's own safety. So I'm saying this now because you all should know that I've had a personal experience advocating for a family member that kind of colors how I see cases such as this.
Yeah.
But then I also understand as an attorney that you have standard of care, duty of care, and that complicates things, right? These are not people that do not have any authority to act upon Maya. They have authority. And we're going to talk about kind of how the law allows them to act within that authority. And so these two things can clash: the authority of the family, the parent, the individual, and the authority of the hospital to treat. So it's very, very difficult, very difficult. So allegedly, the doctors were unfamiliar with this disorder, took issue with the family's advocacy for ketamine treatments, and contacted the DCF hotline. And that DCF hotline call was closed on that day. So they basically received the call, looked into it, and said, there's nothing to be done here. And so instead of releasing Maya to her family so that they could take her somewhere else to be treated, they held on to her allegedly under false pretenses, allegedly. And then Dr. Sally Smith gets involved. So the next day, October 8th of 2016, the family requested to leave and was refused. At this point in time, there was nothing holding them there. You should be able to leave, but they were refused, and allegedly were told that security would be called if they tried to take their daughter out. Dr. Sally Smith was brought in, even though she was not a treating physician on the case. She accessed Maya's health information. And Dr. Sally Smith was working for the DCF private company that reports back to DCF. On October 9th of 2016, the family was denied a discharge to another hospital. Allegedly, a second call is made to DCF from Dr. Sally Smith, alleging, amongst many things, that Maya was not in pain, that Mom Beata had denied Maya a donut, that the mom got mad when she woke up, and when Maya woke up and the family was administering meds at home, the mom had suspected mental health issues. So all of these are things that they're alleging about mom. And when I say mom got mad when she woke up, they said at some point in time, Maya woke up and said she was hungry and wanted a donut. And they're saying that Beata said no, she couldn't have the donut and she was upset. But the family in response alleges that this was completely false, as Beata was not at the hospital when Maya woke up and asked for a donut. Like, that event just did not happen. And that there was no medical basis to assert, excuse the typos, that Beata had mental health issues. Like, they had nothing to base that on, no medical treatment to base that on. So on October 11th of 2016, Dr. Smith calls Dr. Kirkpatrick. Dr. Smith is the one that's making these allegations. She's seen in the documentary doing the deposition. She calls Dr. Kirkpatrick, the doctor that's the expert on CRPS, who cautions Dr. Smith against accusing parents of abuse, because CRPS can cause that mistake to happen based on the, presentation of the illness. Allegedly, Smith ignores this. Smith writes a report excluding what Dr. Hannah, the pain treatment doctor, and Dr. Kirkpatrick had diagnosed in Maya, and alleging pediatric condition falsification syndrome. Dr. Berry, do you have any insights on pediatric condition falsification syndrome? Is that the same as factitious disorder, or is it something else?
And so that might be a medical, because she's a medical doctor. And so there might be an additional medical condition, but I think it's similar to that fictitious. It's in her mind, or somebody else is causing, because that doesn't say by proxy. So that would be that the doctor was thinking that potentially, based on just what I see here, that it could mean that because that's not a DSM diagnosis. So that's where I'm thinking it might be a medical one, but it sounds very similar to factitious disorder, where you're saying somebody is having somatic symptoms that don't have a physical, but you always have to rule out a physical cause.
Okay. So in DCF proceedings, the hospital fails to include their own role in Maya's treatment plan. Beata begins to suffer mentally and expresses that distress to the hospital staff. And apparently there's multiple allegations in the complaint that the hospital staff basically is taunting to Beata, like telling her basically she's never going to see her daughter again. And text, like behind her back, texting about like how basically they're going to get to the bottom of what's going on, and Beata's crazy and stuff like that. And they're acting that out towards her. And the hospital allegedly interfered in visitation with various people, including Beata family members when they were allowed to visit, and her religious rights and religious visitations. There was the testimony we saw from the priest who said that before he got to go and visit Maya, he was told basically that we have to be careful what we talk about with her, because the mother is making her seem like she's sick when she's not.
And before you move forward, can you go back to the last one?
Sure.
Because with that last point of the hospital interfering with the visitation rights and everything, and the accusations that the hospital was allegedly making. So often people have the right to access their religious services, and the only reason you can deny that is if it is detrimental to their physical or mental health. And you often have to document that very specifically. So I worked residential in residential treatment, and anytime if individuals, we weren't able to restrict their ability to call people unless there was a reason to restrict that. And I also think it's important to note that with privatized child and family, so in Florida, they used to privatize those investigations, which kind of gives that agency. I'm not alleging anything. I'm just thinking about this from what would motivate somebody to do some of these things. But when things are private, sometimes there's not the same training across the board. Sometimes people aren't making sure that they're meeting the legal standard, that they are doing that thorough research. And those phone messages coming into play of the hospital staff allegedly making negative comments about mom, because I think they subpoenaed cell phone records.
They did.
And that was how they ended up. So I hope that doctors and people are aware, like you can't do things like it shouldn't have happened, period. And anything that you do that can come up in a situation like this.
Yes, thank you. Thank you for that insight. And that amazing insight. I think the way that you can thank Dr. Berry for that is to like the video so that people can know that we're here. Hey, Kurt. It's just, let people know that we're here. So Beata was not allowed to visit Maya as a part of this custody order, and that this is very upsetting. So prepare yourself. After 87 days in custody of DCF in the hospital, Beata took her own life. On January 13, 2017, a week later, Maya was returned to her father over the objection of the hospital. And in 2018, the Kowalskis filed a lawsuit. So bear with me while I go through these claims. I'm going to try my best to kind of be speedy about it, but there are multiple claims in this lawsuit. If you see the numbers skipping from like count 1 to count 10, it's because a lot of the claims were lost by the plaintiffs on summary judgment because of Florida laws that preclude certain claims against medical professionals as long as they were acting within their, specified capacity. So there is a gatekeeping function there of the statutes to protect medical professionals when they're giving what they believe is, medical treatment, and the judge sometimes outright saying that he disagrees with this particular law. He said that in some of his summary judgment rulings, has dismissed a lot, maybe half of the claims that have been filed in this case. So count 1 was false report of child abuse under Florida statute 39.206, and summary judgment was granted in favor of the defendants. Immunity was given to them because of the reasonable cause for the medical treatment. The judge made it very clear he disagreed with the interpretation of the statute by the appellate courts of Florida, but that he had to go along with what the interpretation was. I read it. I agree with the judge. I read the case law. Doctor, you're a doctor, so maybe you have some
and
thoughts
I
on
think, and I just want to make sure that I understood. So that one, they ruled they ruled for John Hopkins. Is that what that says?
That's right. They ruled for John Hopkins, and they said there was reasonable cause to report the child abuse because they're mandated reporters.
Yes.
Right. And so my understanding from reading the statute, from reading the case law, and from reading the judge's ruling is that essentially you want to be very careful not to discourage medical professionals from exercising their role as mandatory reporters.
So I'm a mandated reporter, and it's not if I have proof of harm, it's only if I suspect. So if that's suspected, that I have to report that. And sometimes that's a call to say, hey, is this reportable? And they could say no. Or but it is meant to keep kids safe and then also protect the reporters as well.
So she did. There you go. Absolutely right. And so I agree with the judge on reading the ruling. And I also understood the judge's frustrations because I think he thought the second report was excessive, but that he felt his hands were tied by the statute that gave the man immunity. Smitten.
And I definitely understand why they said because if she didn't include information from the doctor that had confirmed the diagnosis, that would be the part that would be like, because if I had somebody presenting like that, and if there are medical doctors that have confirmed that diagnosis, but I think it's that suspicion that you have to report.
Right, that you have to report. So she did leave a letter, Smitten Kitten, and it does specifically talk about, I don't want to read it here. I just don't. It's upsetting to me, and I think it could be very triggering. But this was the reason. Okay.
And I believe it was either a few days. So they had a court date right before, and she had just wanted to see, because she hadn't been able to physically hug her daughter in 87 days or in that period of time. And she was denied, even because I think it was said that she shouldn't be able to I don't know, like it was the other side's opinion that she shouldn't be able to have contact,
Mm.
and that continued inability to have contact with her.
Yeah.
That's what she said. And truly, if people are having those types of thoughts, if that is coming up, please reach out for help and support.
Yes, absolutely. So count 2 is false imprisonment, which in some of these, I'm going to give you guys the either statute or case law definition of the civil claim, and then kind of the facts that the plaintiffs are pointing to back that up. So what the allegations are. So these are allegations. Nothing has been proven in court yet. People have testified. Evidence has been introduced. The jury has not made a decision. So false imprisonment count 2 is going forward and is forcibly by threat or secretly confining, abducting, imprisoning, or restraining another person without lawful authority and against her or his will. So this is what the plaintiffs are alleging. Without legal authority, having already reported their suspicions to DCF and having been told, this is the first report, the investigation was closed after the first report, JHACH, the hospital, continued to hold Maya against her and her parents' wills, thus imprisoning her in the JHACH facility. They refused to comply with Jack and Beata's repeated requests to have Maya discharged and thwarted their attempts to have Maya transferred to a more appropriate medical facility. So let me just go ahead.
Sorry, go ahead. And typically there is an option to discharge against medical advice. Like
That's
typically that is, and sometimes that even that sometimes you do report to social services that this child was discharged. We're still concerned about their medical, and then the worker follows up on their care. But the fact that she wasn't allowed to be discharged, that's I'll
proven.
be interested to see what happens.
Yeah, if proven. And the plaintiffs allege in more detail in the claim, the entire claim, I'll put it in the description box, but the plaintiffs allege in more detail that they were specifically told that security would be called on them if they tried to remove Maya from the hospital. And so this is a very succinct period of time between the first and the second report. It's only a day, but basically that they held Maya there under false pretenses in order to do the second report, in order to force the issue to divest the parents of their custody of their child. That is the allegation. So count 5. So we've gone through counts 3 and 4. Those are gone. Those were dismissed in favor of the defendants. Count 5, battery. The offender must actually touch or strike another person. The touching or striking must be intentional. The touching or striking must occur without the consent of the other person. And here the plaintiffs are saying the touching of Maya around the face and body through the actions of unwanted hugging, kissing, patting, stroking, slapping, caressing. Maya was physically stripped of her clothing down to her shorts and training bra, and photos were taken against her will of her partially nude body. And let me just say, Dr. Berry, that the defense here would be that anything that they physically did to her was in the pursuit of valid medical treatment. Like, we wanted to take pictures. This was said in the opening statements, pictures of the injuries, like the lesions, in order to rule out or confirm the diagnosis. We wanted to give her EKG. We wanted to do, or EEG, we wanted to do all these things to her that are valid medical treatments that have a basis in medical science. And we were not just touching her and taking her clothes off for no reason. And the process.
Natalie,
yeah, go ahead, Dr.
There are allegations that the social worker had her sit on her lap.
Yes.
That is strange to me. And I did a video today talking about counselors and ethics and physical touch specifically. So if a client asks me for a hug, so I do side, like, the church hug. I do a side hug. And I wouldn't, if a client needs physical touch in session, I have a family member come with them. I have somebody else. I'm not comfortable being the one to, especially a child, for me personally. And so the sitting on a 10-year-old sitting on the lap of the social worker, seems a little strange to me personally.
That's right. So that is Miss Beatty or Beatty. And it's in the opening statement, it's in the complaint. There's also allegations that she said to Maya, "I'll be your mother now." Completely inappropriate. Just exceedingly inappropriate if proven by some way in the case. And I can see why they dropped the claim against Miss Beatty. She doesn't have any money.
Yeah.
Right? She doesn't have any money. So you're going to go against her, take her to trial and all this stuff. And she will never have the ability to fulfill any judgment, but you can still go through the hospital who hired her. And that's what they're doing. That's what all those claims are about. They're going against the hospital that hired her. So battery in relation to Miss Beatty doing these things, but also other members of staff that were entrusted to the hospital to do these by the hospital, and they did these things. So count 6A was negligent infliction of emotional distress on Beata, and there's also one on Maya, and the ones on the dad and the son, those were dismissed. There just wasn't enough at summary judgment to find that they suffered a physical injury as a result. But Beata, obviously, there is a impact rule in the state of Florida for negligent infliction of emotional distress, which is a unique claim where they have an emotional response or mental suffering caused by an accident or injury. In other states, it has to be intentional. It's a very high burden. Here, it's a lot lower for negligent infliction of emotional distress, but you have to show some type of physical injury came from it in order for this particular claim to lie. And so the plaintiffs are saying that allegedly the defendant's abhorrent actions included berating Beata in person, in public, and over the phone, accusing Beata of abusing her daughter, telling Beata she had very little chance of freeing her daughter and she would likely not live with her again, refusing even the simplest supervised contact, not even supervised contact, between Beata and Maya, including forbidding or impeding correspondence through notes, letters, phone calls, or FaceTime calls, publicly alleging to others, including her husband, Jack, and Beata's brothers directly and through minions like Beatty, the social worker, that Beata was mentally unstable and unfit to raise Maya or Kyle and had all the signs of Munchausen by proxy. Please excuse the little typo issues. So I'll say, legally speaking here, the defense side of things will be they were only carrying out the orders of the court, which were to keep Beata away from Maya, right? Keep Beata away from Maya. And so everything that they were doing was pursuant to what they were told to do by the court system. Dr. Berry, do you have any thoughts on this claim?
And I think the defense is also going to try to say that Maya did get better under the hospital's care, that her pain did go down. But anybody that has chronic pain, so I work with people with chronic pain, and they often say when their pain is a 10, they often say it's an 8. Because people like, oh, it couldn't possibly, like if they say 10, people are like, it couldn't possibly. 10 is the most possible pain you could ever have, or if they say a 9. And so with pain, people can mask that. And I think she just wanted to look, and I don't know this for sure. My guess would be that she wanted to look better and look okay because she just wanted to go home.
That could be. It could be just that she has a chronic illness and that on its own, sometimes unexplainably, it just gets better.
Yes.
But we heard the testimony from her brother that even after it got better, she's had a flare up since then, and it was pretty severe and she had to be hospitalized. So it's just a thing that she has to live with. I'll just remind you guys, we have 715 people here right now. Yay! Hello to all 715 of you. Please make sure that you like the video. That way, Dr. Berry and I can continue to bring you these insights. Thank you so much. Count 6C. So 6A, 6B, and D, I think those were both dismissed. 6C is as to Maya. And the physical injuries and manifestations to Maya, because she survived, she didn't pass away. So the physical injury to Beata is obvious. She passed away at her own hand. And they said that was caused by the stress of what they were negligently inflicting on her. But they're saying Maya suffered psychological trauma, included difficulty eating, loss of appetite, dry heaving, inability to breathe or shallowness of breath, headaches, weight loss, anxiety, and insomnia. And they're saying all of this is due to the behavior of the medical professionals. So then we skipped count 7. We're on to count 8. medical malpractice. So for medical malpractice, I'm not going to read this all the way through. You could just look at this, but there's 4 things that have to be proven with medical malpractice. So there has to be a duty. Obviously, a hospital has a duty to take care of, physician has a duty to take care of their patients, a breach of that standard of care. And that's where a lot of this trial is going to lay, is did they breach the standard of care, right? This is really, really hard to prove. It's necessary to assess what your own provider did and how this compares to the hypothetical physician. You need evidence showing how your doctor deviated from what another practitioner would have done. Your medical records have to show a diagnosis, treatment, your medical history, and other factors. Medical experts are also useful. So they do have medical experts that have testified so far. They have to show a harm to the patient. I think the harm is pretty clear when it comes to Maya, and causation, that what the doctor did in breaching the duty of care caused the harm to Maya. That's also a difficult hurdle to overcome. Do you have any thoughts on medical malpractice claim?
I was surprised, especially with them thinking that she had a psychological condition, that she didn't receive more counseling.
Whoa. Oh my goodness.
Are-
Okay,
are-
let's talk about that, because the expert physician doctor said she didn't, 4 hours or 3 hours of cognitive behavioral therapy in months?
in 3.5 months.
And you're saying she has a psychological disorder, but you're not giving her psychological treatment?
And before she was admitted, she had a therapist that she was seeing every week.
And they disrupted that.
Yeah. And didn't replace it. And the defense, he started talking about physical
therapy. What?
And
Oh yeah,
therapy?
I definitely saw that. Physical therapy. He's talking about, give me a break, Dr. Berry. They are not the same.
No. And because I can't wait for, I hope the prosecution wrote it down, or whatever you call, but I hope they wrote it down, that because he said that physical therapy is the primary way that you treat Munchausen. And no, counseling, counseling is,
it doesn't make any sense. It doesn't make any sense. You think that they cannot stay on task. On one hand, oh, the physical disorder is caused by a mental disorder, so you don't give her the mental disorder treatment, but then you're billing the insurance company for the physical disorder. Okay, we'll see. I'm keeping an open mind, though. So count 11 and 14 are negligent supervision and negligent hiring. So let's talk about these kind of together. So negligent, we're really talking about Miss Beatty, the social worker. We're talking about the social worker here. So basically saying the hospital is liable for what she did. So negligent hiring occurs in Florida, when the employer knew or should have known of the employee's unfitness prior to the time of the employee being hired. Negligent retention, keeping someone negligently, occurs when during employment, the employer becomes aware or should have become aware of the employee's unfitness, and the employer fails to take steps to discharge, reassign, or engage in further investigation. So that could arise during the course of the treatment. You become aware, wait a minute, something's not right here. So in Florida, however, there is a statutory presumption against negligent hiring in statute 768.096, and says that there is a presumption against liability for employers in negligent hiring cases when the employer conducted background investigation of the prospective employee, and the investigation did not reveal any information that reasonably demonstrated the unsuitability of the prospective employee for the work to be performed or for the employment in general.
So I used to hire mental health counselors. I oversaw a school-based therapy program and would hire probably anywhere, because I would have anywhere from 15 to 20 clinicians at a time. And the agency did a background check. We looked into people's education. We looked into all of that. And we would periodically, because our staff would sometimes drive clients, we regularly checked their DMV record, because if they had over a certain number of points, they couldn't drive clients, and they wouldn't lose their position, but you just couldn't have a client in your car if you had a certain number of points. And I think this is about the alleged past CPS allegations against that particular social worker.
Yes. Go ahead. No, go ahead. Yeah. Yeah.
And I think the family found that out. I think they were like, how is this individual the one who's deciding things, and she has her own history
Mhm.
of alleged abuse, and like we haven't abused our daughter and
Right.
she's the one
Right.
that's investigating us.
So,
And
which is insane. Sorry. Absolutely nuts. Yeah. Sorry.
no, you don't have to apologize. It's so like it was that part because so if I have a clinician, so if a parent makes me aware that somebody on my staff that they had abuse allegations, I would immediately have to, okay, you can't see clients. We have to now do an updated background check. Like I would have made sure because our first priority is the care of our clients.
That's right.
And so I would have had to look into it, and there were times that something came back on somebody's background check.
Mhm.
And if we could get more information, like there were times that if we could get proof that something was discharged, or and then we would document it on our end, our due
Mhm.
diligence.
Mhm.
But that was
No,
I
that's
wasn't that was surprising to me.
very surprising and such a breach that this person so that okay, the law is built to give the hospitals a protection as long as they do a simple thing. Do a background check. And if you did a thorough background check and it just for some reason doesn't come up and it wouldn't have come up no matter what you would have done, you're covered, right? But here you see they did a summary judgment motion as to this count. The plaintiffs, I mean the defendants did. And they said, "Judge, don't even let this go to the jury. Just dismiss this count because we did a background check." And the response was, "Excuse me, she has an abuse history." And somehow either you didn't find it because you didn't look or because of something. I don't know. You just didn't find it. So you cannot say that you did what is supposed to be done as far as the background check is concerned. And so they could not get summary judgment as to counts 11 and 14. So they're on the hook potentially for the actions of the social worker, which were bizarre to say the least. So count 18 is fraud. Okay. See, we jumped from 11, 14 to 18, right? A lot of counts have been dismissed before it gets to the jury on summary judgment. A lot of it because of statutory protections for medical professionals. And that's a subject of another video. We're not going to go into those ones that the jury's not really considering. So fraud civilly in Florida is a misrepresentation of material fact by a person or entity who knows or believes it to be false, a person or entity who justifiably relies on the misrepresentation and actual injury or loss. So I was like, well, what was the fraud here? Well, then we start hearing the testimony. I look at the complaint. And it makes sense now why certain questions are being asked and certain arguments are being or statements are being made in opening statements. So they're alleging that the hospital's deceptive practice of denying her diagnosis while continuing to bill the Kowalskis and their insurers for this treatment of the diagnosis of CRPS continued through January 2017 and even beyond the point at which Maya's mother took her own life to free Maya, outrageously at the same time that they were arguing to the dependency court that Maya, that's a child custody court, needed to be transferred to an inpatient psychiatric program to address her psychiatric conditions, and continued to insist that Maya did not have and never had CRPS. The hospital was billing the Kowalskis and their insurers for CRPS treatment and services. You heard from the defense counsel in opening statement, them basically saying, well, we didn't actually bill the Kowalskis, we billed the insurance company. Well, excuse me, everyone has copays.
Yeah.
Everyone pays into their insurance. So if
Yeah.
you're billing my insurance company for something that you're not treating me for, you're billing me.
That's how medical billing works. Like that's just how it works.
That is such a lame excuse. And outside of that, if you're going with the plaintiff's version of events, it's still potentially fraud if they're billing for it and they're then turning around and telling the dependency court that Maya is only suffering from psychiatric issues, but they're billing for something that they're saying she's not suffering from. So you could be committing a fraud on the court at the detriment of the Kowalskis, to the detriment of the Kowalskis. So there's that possibility as well if you take out the insurance paradigm.
And my thoughts on that, because I worked inpatient for about 6 months
Mhm.
at a children's mental health facility, and they would have to get cleared medically before they
Mhm.
could come to the psychiatric hospital.
Mhm.
And what would happen is, if the medical hospital was billing for that diagnosis for that period of time, at some point the insurance company is going to say discharge, or like this is not like, if it truly is a fictitious, like, why are we doing more tests? Why are we like, they would be like, y'all put in foster, like, there's a different treatment plan.
Mhm.
If this is what's going on, you have to transfer the person to a different level of care.
Right.
But and I don't know how, but like, I heard some reports that there were some doctors that maybe agreed with the diagnosis, and
Mhm.
that really it was Dr. Smith that didn't agree with it.
Mhm.
And yet the billing department was getting the CRPS.
Yeah, so there were doctors in the hospital that agreed with the diagnosis of CRPS, right? There, that definitely is true. But it seems like once Dr. Smith took over, she just took over. The issue here is that Dr. Smith doesn't work for the hospital.
Yeah.
She works for the Suncoast, whatever private company that was doing the children's services reports. So she's already out. The case has been settled as to her. So there is an issue here of who does that liability go to? Does it go to the doctor and the private company, or does it go to the hospital?
Or is it both?
Or is it both?
Because
That there's something that the family says, Dr. Berry, I think that's very interesting. Or is it both? There's something they say. I'm going to get to that. So, fraudulent concealment. This is the next count. I lost count. I stopped putting the counts down because so many of them were dismissed and whatever, partially dismissed. So to prove this, the plaintiffs have to prove that the defendant, the hospital, knew their concealment of or failure to disclose the material fact would induce the plaintiffs to act. And the defendants had a duty to disclose that fact, and that the plaintiffs detrimentally relied on the misinformation. So how does that apply to this case? So they're saying the defendants and Smith, Dr. Smith, covertly conducted video surveillance of Maya for approximately 48 hours between October 18th and 20th of 2016 to catch her in the act of faking her CRPS, i.e. the charade, stating plainly in text messages that Maya would make physiological mistakes and could not keep up the charade 24/7. So those text messages really bit them in the butt. The hospital and Dr. Smith knew that this video surveillance contained exculpatory evidence because they're saying it showed Maya being unable to go to the bathroom, needing assistance, being unable to dress herself, having the physical manifestations of CRPS, even when she was being surveilled and she didn't know it. But rather than disclose that exculpatory evidence, which would exculpate her from the allegations that she was faking it, the defendants pretended it did not exist and never mentioned it to the Kowalskis or the dependency court. Rather, they and Smith intentionally withheld the information for the purpose of inducing action on the part of the Kowalskis and the dependency court. Actions being to divest the Kowalskis of custody of their daughter.
So I saw someone else mention that often in CPS cases,
Mhm.
that families sign a care plan. Like, families
Mhm.
are just, there's this
Mhm.
risk, and in order to see your child, sometimes like you have to sign this in order
Mhm.
to be able to see your child. And it's my understanding that they never agreed
Mhm.
to the care plan, because often the care plan is saying, okay, I agree with your, or like, I just want to see my kid. But
Mhm.
sometimes that if they had signed that type of document,
Yeah.
they wouldn't have been able to file this civil suit.
Mhm.
And I just thought, because I hadn't heard that before.
Right.
I've worked with families that did
Mhm.
have care plans in place, that did
Mhm.
have certain involvement, and there's often requirements, because it does sound like, I think they just never signed it. I think there was a care plan and they just refused to sign it.
Yeah. And they consulted with the attorney pretty early on, and I'm sure that attorney would have advised them not to sign the care plan because it is essentially, a lot of them, I haven't seen one in Florida, but in Maryland, a lot of them are an admission of some form of abuse or neglect. And here's how I get back on track so I can see my child.
Yeah.
So it's tough. And so as this fraudulent concealment claim, what this is really saying is they lied to us by omission. They surveilled our daughter in her intimate moments when she was like, trying to wipe herself and all types of stuff where they're like, she's adjusting her sports bra. She's doing stuff a little girl is doing in her room without knowing that people are watching her to try to catch her out. And instead, what they discover is that she actually does have these manifestations. And they don't tell anyone this. And they don't use this surveillance for actual treatment, which is another count that they're going to get to. So intentional infliction of emotional distress is the next count. We've talked about this count before in this civil claim. In other cases, and as I've told you guys, it's a really, really hard claim to make. Deliberate or reckless intentional infliction of mental suffering, outrageous conduct caused the emotional distress, and the distress was severe. Those are the 4 factors. Remember the Brian Laundrie case, Gabby Petito case, where the parents of Gabby Petito are suing the parents of Brian Laundrie, alleging intentional infliction of emotional distress, and that claim was allowed to go forward. This is the same state, so the same standard, Florida. So the plaintiffs acknowledged that Maya this is something they said that I had to just rip this completely from the complaint and show you guys. So the plaintiffs acknowledged that Maya was sheltered upon court order, but the defendants cannot escape liability for their conduct simply because Maya was left in their care and custody. Let me pause there. In their opening, defense counsel was saying, we were only doing what the courts told us to do. They told us to keep Maya. And they're saying we're warehousing her, but that's what we were told to do by the courts. And what they're saying is, it doesn't matter. If the courts say that you should keep a child, you still can't inflict emotional distress on their parent and on the child. You're not allowed to do that. So they said, just as a foster parent cannot abuse a child simply because the child had been placed in their home by the state. During Maya's sheltering at the hospital, she was battered in a sexual way by Beatty after being put under the charge of Beatty. That's a social worker who had a known criminal history and or history of attempted physical altercations. Maya was repeatedly and incessantly told that she was the problem, she was crazy, she was faking it, and that her psychiatric conditions and feigned illnesses were the cause of her extended separation from her parents. So they're saying they told her it's your fault, and they put her in contact with a social worker who was abusive. This is their allegation. She was told on a regular basis by Beatty that she would never see her mother again. Smith, that's the doctor, as an agent of the hospital, not really, and Beatty at the direction of the hospital's risk management, as well as certain doctors upon information and belief, include these other doctors, and others directed that Maya be locked in a dark room for 48 hours to prove that Maya was faking her CRPS affliction. Dr. Berry, any thoughts on that?
So that in and of itself is, so you can't seclude someone, like someone will lose it. So that's seclusion. So once again, I worked residential. I did, I've done a lot of different types of care. We had to get a doctor, we had to get someone to prescribe seclusion if we ever did it. And we had to closely monitor the individual because like I wasn't aware of that one.
Yeah.
That in and of itself could cause significant psychological harm because you are not, like, sometimes, because dark room, you're cut off from light, you're cut off from all sensory things. And do they not understand that stress increases pain?
That's the thing I want to know, because when I'm having a terrible migraine, stress is the worst thing for that. The absolute worst. And I also want to say here, I'll add in the defense perspective, and that is, if they said, well, we were doing this because they were giving an EEG at the time, we needed
48 hours?
48 hours. They had her hooked.
Excuse you?
Yeah. That was the standard of care. That wasn't outside the standard of care.
Wait a minute. Was that a neurologist? Because what? I thought so as a psychologist, I do not have training to administer an EEG, and I have no opinion about, But that's where I wonder if they would lean on Dr. Smith allowing that too.
Yeah.
Because you would not. That is not a typical standard of care. Now you might do a sleep study. You might
Mhm.
do continuous monitoring of an
Mhm.
individual using using an EEG.
Mhm.
I did do EEGs in undergrad. We would do it with research, but that is not that's outside of the normal standard of care. Or if you are thinking somebody is faking something, you wouldn't go that far,
Mhm.
because that in and of itself could cause distress for
Distress.
she was 10
To just
to a 10-year-old, because like I would be losing it at 41, but this she was 10.
and they're saying that she's mentally ill. And so they're going to do things that would stress someone who's not mentally ill to a what they perceive as a mentally ill child. It doesn't make sense to me. But this is what they allegedly did. And what they are saying that they're justified in because it was the standard of care. So this also ties in with the intentional infliction of emotional distress, engaging in unnecessary diagnostic testing. This is a claim. And this is a Florida claim, pretty unique to Florida. They're not the only ones that have it, but they're in a minority. So no healthcare provider shall procure, provide, or administer unnecessary diagnostic tests which are not reasonably calculated to assist the healthcare provider in arriving at a diagnosis and treatment of a patient's condition. Any person who prevails in a suit brought against a healthcare provider predicated upon a violation of this section shall recover reasonable attorney fees and costs. I mean, we really don't like you because we're also going to give you back your attorney fees and costs, which most claims do not. And the plaintiffs are alleging that that is the unnecessary EEG and surveillance ordered and not used in the treatment plan. So to add insult to injury, the results of the EEG were never used in her treatment plan. So they surveilled her clandestinely for 48 hours allegedly in a dark room. And they didn't even allow her to go to the bathroom. Like, they didn't put the commode next to her. They put the commode far away, so she had to get help to go to it because she couldn't walk on her own. They were trying to see if she would get up and walk to the commode, and she couldn't do it, so she had to ask for help, and it was embarrassing. And they said it was unnecessary. They did it. They basically performed an experiment on her. These private moments and or actions included numerous instances where Maya undressed her bottom half and used the bedside commode, wiped herself, changed her clothing, and adjusted her training bra, all on video, not knowing she's being videotaped by the hospital staff. And they said that that was engaging in unnecessary diagnostic testing, which is a claim in and of itself. Dr. Berry?
Especially because it wasn't used in any, and her medical team, I don't know that her medical team was made aware, or that they would have to look at that.
Mm-hmm.
If her medical team was even made aware of all of those updates and diagnosis and all of that.
And what's kind of interesting to me is that the defense is not taking the angle of this event didn't happen. They're just saying this was the standard of care. Like, this was within the standard of care. This was okay. And I don't think anyone who's a parent who has advocated for someone who has medical issues, who has had a chronic issue or been hospitalized, would feel that this is the standard of care. I would not like to know that my doctors are secretly videotaping me. That would make me very, very angry. And that they didn't use the information that they got, like, to actually treat me. They were just trying to find me out. Like, I don't like that.
And the only thing, because I think they were trying to prove that she wasn't as sick as as they were saying that she was. And to me, after they got that, I think if they had discharged her, I don't think I don't know that the family would have sued, or I don't know, like if this had, oh wow, there really is an issue, let's follow up, maybe this is legit. But the fact that things that didn't go along with whatever the narrative, I think the fact that this wasn't included, I just wonder how the jury's going to see this.
Yeah. And they call that confirmation bias, don't they, Dr. Berry, where you disregard evidence contrary to your hypothesis?
Yep, completely. And we have to be careful of bias, because And I think, and it's sad when people feel that what they're doing is honestly in the best interest of the child.
Mm-hmm.
Because, there are messages after, the loss of Beata where
Mm-hmm.
supposedly the hospital was sending messages that she's better off, like, that the
Mm-hmm.
family is better off, and
Mm-hmm.
messages like that, just
Mm-hmm.
like that people still thought that it was the mom and the mom was the problem,
Right.
when from where I was, from what I've seen so far, it just seemed like Beata was just trying to get the best care she could for
Yeah.
her daughter.
For her daughter. And I feel as though, from what we know so far with the testimony and everything, they felt that she was an adversary
Yeah.
and that they had defeated her, you know, and that's terrifying. So there is no way that I am going to get to everyone's favorite part of this trial. Impossible, right? But we're an hour and 15 minutes and 3 seconds into this live stream. There are 826 of you. Thank you so, so much. If you all like the video right now, I know that we can get to 1,000. I know we can. So please do that. But I am going to play you guys little snippets of each piece of the trial. I think the only snippet I didn't get was of the priest, but that's okay. I'll still figure out a way to get him in here. But I've got everything, I think. So, and again, Dr. Barry, if there's something that, pings for you that you want to talk about, please let me know. This, I think, is about 10 minutes long. I'm just going to let it play. This is the plaintiff's opening statement.
Upon realizing their error, for the next 3.5 months, they took every step in the world to attempt to force the Kowalskis to agree with the wrongful diagnosis.
Uh-oh, wait. Let me just make sure. Oh, it is there. You can hear it, right?
Yep.
Okay,
Yep.
great.
Maya Kowalski was falsely imprisoned and battered. She was denied communication with her family. She was denied communication with the outside. She was told that her mother was crazy. She was told by social workers that one in particular, she would be her mother. She was put into a room and left for 42 hours with the commode just out of reach because the hospital wanted to prove that she could actually get up and walk. So they wanted her on video, this was a surveillance room, to get out of bed and then go over to the commode when nobody was watching. Instead, she defecated on herself. For 42 hours, she was kept in that room, denied access to anyone or anything, under the false assertion that it was an EEG exam. Maya was repeatedly battered by nurses and social workers who were trying to prove that she did not have CRPS. Things were done such as coming in and patting her on her leg. They were hugging her against her will, took her down to the chapel, sat her on the lap of one named Kathy Beatty, who told her that she would be her mother. Her mother was, crazy. And that she needed a mother, and that social worker would be there. Maya was kept from her family and friends. She was denied access to her priest. She had what they called religious artifacts, such as holy water, her prayer book, her rosaries taken from her on the belief that her mother was controlling her over religion. She was denied access to counsel, at least insofar as having the ability to actually meet with her attorney without people listening in at the door. All of her phone calls were monitored. Her iPad, computer were taken away because she was told she might be, this is a 10-year-old, cruising internet sex sites.
Oh my God. Remind you of anyone?
Maya was denied the
8
comforts of her
passengers.
friends and her family throughout her stay there. On another occasion, again, to try to show that Maya did not have rather significant symptoms of CRPS, which you'll see are these small little red, angry lesions that appear on different parts of the body, underneath the arm, along the arms, sometimes on the legs, sometimes on the back.
Mm.
And you'll see photos here in a moment. But in order to prove that she didn't have one, she was systematically stripped and photographed against her will and without any authorization from anyone, least of all her parents. They continue to accuse the Kowalskis, Jack and Beata, of being child abusers, even after the evidence, we believe you'll conclude, was overwhelming that she had CRPS. In fact, we will see whether at some point they even admit she had CRPS in this case.
Hmm.
Yet they still,
the
throughout this
billing.
period of time, continue to
The
accuse
billing. The billing does them
Beata
in.
of child abuse and Jack of child abuse, something called Munchausen by proxy, which means that you're intentionally trying to keep your child ill. It's usually a circumstance with a very small child where a mother will be like putting something in an IV or things like that.
Mhm.
Maya at this time was 10 years old. There's
So
no
true,
evidence
Tiffany.
whatsoever of Munchausen by proxy. By January 13th, when Maya was finally left out of the hospital, unsurprisingly, this family was a wreck.
Hmm.
Maya was not let out of the hospital even after her mother committed suicide on January 7th
Hmm.
of 2017. Now, the story with Beata Kowalski is a complex one, and I'll tell you about it in a moment. But we will prove that the continued allegations that she was crazy and that she was trying to harm her own children, both Kyle and Maya, and the knowledge of the systematic abuse of her child in the hospital caused her at the end to lose completely and utterly her ability to control the maternal instinct, and that outweighed the survival instinct.
Oh God.
In the process, they caused Beata Kowalski her life, denied Jack a loving wife, denied both Kyle and Maya a loving, caring, and amazing mother. They caused just terrific and permanent psychological injury, as one may expect, a permanent aggravation, and we'll explain the medicine behind that, of the CRPS. Now, the CRPS didn't start with Johns Hopkins. It started about 3 or 4 days before Johns Hopkins. But the evidence will show that something that could have been a controllable, manageable disease was aggravated to the point where throughout periods in her life, she will be incapacitated. And through all of it, she and her brother and her father will have post-traumatic issues and problems that will, frankly, we'll get that into that in a moment.
So, I see some people saying that there's been some, I guess, criticism from other creators about the way in which he delivers this opening statement, and it goes on for over an hour. I think they were each allotted 90 minutes, and I need to watch what that criticism is. I can anticipate maybe like his style of delivery or something like that, but sometimes the facts are just so horrific from your perspective of your side that a more laid back approach is appropriate, because I think that it makes you absorb more. Like the theatrics might not be so great with something like this. This is pretty horrific what they're alleging here.
And if you're too theatrical, like the jury might shut down
Mm-hmm.
if things are too intense.
Mm-hmm.
To me, it came across like well paced. I didn't have any particular criticism about it. Every lawyer is different. I'm sure you know.
Yeah.
And I think people sometimes have their preferences of like, oh, I might have done
Yeah.
it like this. But
Yeah. I'd be so interested to see what other attorneys think about that opening, but I think that it did what it was supposed to do from my watch of it. That's not the whole thing. I encourage all of you to go and watch it. So this is a portion of the defense opening statement. And now I think defense counsel in this case is very good. Obviously, hospitals are very moneyed. They can afford really, really good attorneys. This man is an excellent attorney, I can tell. So let's listen to it, and I'll give you guys my feedback, and so will Dr. Berry.
Now, as of October 7th, we had the Kowalskis seeking out care at all Children's, as I've said.
Mm.
We believe the evidence is going to show you that care was reasonable and necessary and appropriate. And indeed, we're going to suggest to you the evidence I'm about to discuss with you will show that what went before, the treatment that went before, did not necessarily fall into that category, any of those three categories. And that is the reason, one of the big reasons that we're here today. Now, as of this date, as of the time that Maya Kowalski was discharged from all Children's, we believe that in fact, she had been set on a path of therapy that has enabled her to resume function, to get out of a wheelchair, to be relatively pain-free, and to be in a situation of participating in her school and in society as she does today. So how did we get there? Well, on October 7th, Maya Kowalski was brought to the emergency room at all Children's. As you've heard, she had bad stomach pain. She was screaming, crying, thrashing around, cursing at staff, very upset, and
Cursing
in a
at
very
staff, we
challenging
got to include
situation
that.
for the staff. She had pain in all her extremities. She had her whole body being said to be hypersensitive to any kind of touch. She was unable to walk. She had legs atrophied from disuse, from being in a wheelchair for months at that point, or maybe over a year. She had dystonia, alleged dystonia, different position of her feet, as you've heard. And she was demanding pain medication in large quantities. Mrs. Kowalski arrived a while later, and you're going to hear that when she arrived, she forbade the doctors and the nurses to touch Molly. The doctors and the nurses wanted to assess her, to examine her, to put on a blood pressure cuff, to put on an O2 sat monitor, to take a temperature, and they wanted to find out why there was all this horrible stomach pain. Was it appendicitis? Was it a torsion of the intestines? Was there something badly wrong that an ultrasound or a flat plate of the abdomen or a CT scan could detect? Those questions were being asked. Mrs. Kowalski insisted before there be any workup of the child, she wanted ketamine. Now, not just any amount of ketamine. You're going to hear a lot about ketamine in this trial. Ketamine is indeed an old drug, and it's a drug that is approved by the FDA for use as an anesthetic. It is not approved for use in children, nor is it approved for use in high doses as treatment for CRPS or chronic pain. That's one of the issues here. It's not just ketamine itself, but how it was used and the quantity in which it was used. Because ketamine is an anesthetic. It is an hallucinogen. It can create dependency. It can cause depression of vital signs. If not properly monitored, it can cause serious injury life-endangering consequences. Mrs. Kowalski on this day was challenging the staff to give her daughter a dose of 1,500 milligrams of ketamine. That is a big dose. That dose you're going to hear is several times, many times, the maximum dose that Policies et al. Children's approved. You're going to hear experts tell you that is many times any kind of safe dose. And you're going to hear the ER doctor who was on duty that day, Dr. Layla Behar Posey, who you're here from by deposition because unfortunately she's no longer with us. And I mean that in this life. She'll appear by deposition, and in her deposition, you will hear her tell you what she did and why she did it. And you'll hear her tell you most pertinently that even if she was so inclined to give that much ketamine in the emergency room where she didn't have sufficient monitoring availability, she didn't have the capacity for long-term wake up and intubation. For that period of time, she didn't have the facility she needed to do that. Even if she was inclined to give it, which she wasn't, she couldn't safely do it in that setting. Now you're going to see that Dr. Behar Posey is not just a newbie out of medical school. You'll hear in her deposition what her qualifications are. You'll hear that she's board certified in pediatrics as well as emergency medicine. She's confronted a lot of patients, difficult patients, patients in extreme pain. You're going to hear that this patient, as far as she was concerned, had some degree of uniqueness in that she'd never seen anything quite like this, and she'd never heard of these doses of ketamine. What she found out ultimately, and what developed over the next few days, and actually the next few weeks, is that Maya Kowalski had been given thousands, tens of thousands of milligrams of ketamine over the preceding 9 months.
By a doctor.
Dr. Hannah had given her the day before admission 1,250 milligrams of ketamine. And at that time,
I hate to do this because I do want to. I want to say that, first of all, his pacing is wonderful. He's legally speaking, making great points, but just factually speaking. But then you go and accuse the mom of abuse when she was doing everything she was doing was under the care of a doctor that this hospital knew was treating her, and that they had previously concurred with the diagnosis. That's just kind of blowing my mind.
And I don't know. So now medical records seem to be, because I went for a primary care appointment, and my doctor, for some reason, there was like a national system. They were able to pull up everything. Like they were able to easily pull up a bunch of different stuff, even from hospitals that were out of that particular network. And I think that's a newer system. I've sometimes seen in ER situations where they don't pull up the full where people, they might not look because they're so used to like problem, treat it. They don't necessarily always get the full history. I would guess the family might have mentioned that but I just wish that they had consulted with that doctor, that they had consulted, okay, this is what's going on. This is the amount of pain that she's in. We can't do that here. Or instead of immediately going to this is psychiatric.
Yeah,
this is psychological condition.
The psychological condition of the child, and the mother is crazy. And also, I mean, I guess we're going to have to wait for the testimony to come out, but it does appear that they spoke to Dr. Kirkpatrick and Dr. Hannah. And both of those doctors were like, yeah, she has this disorder. This is how we're treating her. We know that it's outside of the convention and the norm, but this is what's working for her. So do they want to have an issue with the doctors? Okay, two medical, we both disagree. We disagree on what the treatment could be. I'm okay with that.
And
But
he planted seeds of we saved her.
yes, it's because of us that now she's on a better path, because we forced the doctors to temper themselves. Basically, that's what it sounds like. Okay, but then are you going to accept responsibility that's because of you that you pushed the mom to no longer be here? I don't know. Careful with that. We'll see. But no, it's a good opening. It's a really good opening.
He's going to testify to you that he told the mother he was no longer comfortable giving that much ketamine, that it was too much for him to give in his outpatient clinic. And he actually sent her to All Children's. You're going to hear that over the 9 months preceding this, that he had given her a gradually increasing doses of ketamine, 12, 15, over 20 milligrams per kilogram per hour, which is dozens of times the safe and effective dose that was approved by the hospital and that is talked about by the FDA, and that it's never been written up in the literature. You'll hear Dr. Hannah say, either by deposition or by admission on that witness stand, that this was at or near the highest per capita dosage he had ever given any patient. It wasn't working. So what had happened was that he had maxed out with this ketamine dosage. He had sent her to All Children's, and Mrs. Kowalski, despite what he had told her, despite what had happened over the last 9 months, was demanding even more. Dr. Posey heard this story from the mother. She heard how much ketamine that the mother said Dr. Hannah was giving. She heard what the mother was demanding. She saw what was going on with this child. She'll tell you what her suspicions were about the child's condition and what was actually causing it. But she called Dr. Hannah's office herself. Now, she learned that he gave 1,250 milligrams. She learned what else had happened the day before. And so she decided that she would attempt to stabilize the child. She literally she'll tell you about literally negotiating with the mother to give a small dose of ketamine and some sedative, to conduct an examination, to admit the child to the pediatric intensive care unit. You'll hear it called the PICU. And the idea that she had at that time was, let's get her in the PICU, let's get her evaluated by pain management, let's see what's really going on here, let's get her stabilized, and then let's see if we can wean her down off all this medication she's been given.
So what he's presenting there is standard of care. What he's presenting there is, we had a treatment plan and everything we did was in pursuance of that treatment plan. And so it's not like they don't have a defense. They have a defense. That's a cognizable, reasonable legal defense. What are your thoughts on that, Dr. Berry?
I don't think, and maybe he gets into it later, but that doesn't, because that's still, she has this diagnosis and we're going to treat her, and the family would still be able to visit. The family would still be able to see her. She would still have contact with her family. I think at some point things shift, and it sounds like the hospital, that there were people within there that did not believe that she had a physical condition, and that's where things just go.
Right. Because if that's all that happened, where's the case, right?
Yeah.
But instead, we have allegations of child abuse being made, the child being put in a dark room and videotaped clandestinely. We've got social worker touching her inappropriately, allegedly. All these things, which indicate to me that there was, and then the text messages going back that were derisive about the mother, indicates to me that the actions were more than just let's titrate her down from the medication. Something else is going on here. But that sounds good. That sounds honestly sounds good. Neighbor testifies about Maya's symptoms. This gentleman is Brandon Woodward, and they're trying to make they're trying to prove by proxy through this trial that mom was over exaggerating. Kid is making it up. They're still low key kind of saying that. Do you see what I mean, Dr. Barry? Like they're saying, oh, like something was going on with mom, so we were right to do the things that we did. Symptoms were being over exaggerated. She was being over medicated. She's fine now. So we were right to do what we did. So what the plaintiffs are doing is laying out Mr. Woodward, who is like independent of anything that's happening in the hospital. He observed certain things about Maya and Beata.
Do you have a good sense of humor?
Yes.
Now, and what about Maya up until July 3rd, 2015? Did she appear to be a healthy child to you?
Yes.
Moved well?
Yes. She was always out and about doing something.
Okay. Now, I want to take you back to July 3rd, 2015, the neighborhood bike parade. Either that evening or the next day, was there an event that occurred involving Maya Kowalski that was unusual from your perspective?
Etched in my brain forever. So it was actually the night that evening after the bike parade, and we got back to Jack's house. The whole neighborhood was there doing the potluck dinner thing and barbecue. I can't recall what time it was. It was dark. It was in the earlier evening. I went into Jack's house to use the bathroom, and when you walk in the front door, he's got a very wide open, grand living floor plan.
Do we have a photo of that for demonstrative aids only, Your Honor?
Members of the jury, I understand that this photo is going to be a demonstrative aid. This photo is actually not going to be received as evidence.
So if you could describe a little bit what was going on.
The front door is actually just slightly to the left of the pillar you see, which is where I walked in. And there was a handful of people over by the bar stools you see. On to the right of those bar stools is the kitchen area. There was a couple parents in and around the area. I don't recall exactly how many, 4 or 5, not many. And as soon as I walked in, I heard what was, it's a very difficult noise to describe. It sounded like almost gasping panic, but somebody being insanely hurt at the same time.
Did it sound like a child or sound like an animal?
It sounded like a kid. I almost thought it was a kid trying to make a terrifying noise. And I kind of chuckled like, what is that? And then I realized the look on these other adult faces was not panic, but
Was this the reaction when
it was a reaction of fear of not knowing what to do. And then I realized it was a child. So I figured this was not my business or my place. Something was going on that was pretty serious. And I just slowly backed out of the house.
Did you see whether Maya was on the floor at that point?
I couldn't visually see her.
Okay.
I saw Jack kind of hustling about in that area, and I just assumed it was one of his kids, but I did not visually see.
Did you later learn that that was in fact Maya?
Yes.
So from that photo we saw then during the parade a few hours earlier to this time, over the course of how many hours would you say it was?
Purely guessing 3, 2.5.
So you observed Maya moving around well, and then knowing but hearing her on the floor with that sound.
Yes.
Right. What happened after that?
I believe Beata took her to a hospital or a doctor. Jack stayed back.
Did you have?
Okay.
And then a lot of the neighbors kind of started to filter out. We all kind of knew something had happened. There was a big cleanup involved at the party. That's my last recollection of that night.
Put a big damper on the party.
Pretty much.
Okay. And when was the next time that you saw or heard from Maya?
I can't exactly recall. I just remember her being back
at the house. I don't necessarily have a specific timeline of.
Was this a matter of months, say around Christmas of 2015, or?
Well, after that event happened, everybody was checking in on them. How's Maya? What's going on? And kind of the answer was, we don't really know. So I think it's just something you do as parents. How's your kid? You constantly ask and check in. I revert back to, our kids were at the bus stop at the same time too.
Right.
So when you walk down to the bus stop, or just when we take our dog out for a walk, they're always outside. You pass them. What's going on? How are you? How are the kids? How's Maya? That just became daily talk.
Just from the reference point of July 4th time period up to Christmas and after, did you ever see Maya out? And if you did, was she walking or was she in?
No. Wheelchair is all I remember. And if we were at Jack's house, inside the house, there wasn't walking. She'd use her arms to move around and kind of crawl up onto a couch, onto a seat. There wasn't.
Okay. And so did there come a time?
So I pulled this part of the testimony because I think it shows what the plaintiffs are trying to show, which is that Maya had symptomology outside of the hospital that was not just for show for medical professionals, for attention for the mom, right? Which is, what they're trying to say Beata was doing. Dr. Berry, do you have any thoughts on this testimony from Brandon Woodward, the neighbor?
Nothing to add. I think it was real straightforward.
Okay, somebody doesn't like his face. And I thought I'm sorry, that distracted
I
me.
saw that. No, I saw that at the start. They might have mentioned it a few times. So there was a lady with a hat today. I think that might have been today. Like a religious person. It's a white hat. Like it was like a church hat.
Yeah, I missed that.
There was a hat today.
Oh dear. Okay, I definitely missed that. Okay.
What was your
So this is Robert Ryness, and I thought that this was interesting because he's going to talk about Beata's personality, which is interesting, and also the hospital kind of makes it seem nefarious that this ketamine treatment. I mean, I'm gonna be honest with you. If out of context, if I'm hearing that you're going to Mexico to put your kid in a medically induced coma, that's going to freak me out. Okay. I'm not going to lie about that. That's weird to me. Right. And he kind of provides some context that, like, how did they get to Mexico? Why would they think to go there? Who they are as parents. And I think that this is interesting. I wonder what you guys think about this. So I'll play this little portion for you.
I loved her.
This is what he thought of Beata.
She's just she was just a wonderful person. I respected her because she was very to the point. She didn't hold any punches. She told you how she was feeling, but she was just a loving, sweet person. Loved to teach me how to make pierogies, and she was a great person.
How would you describe their relationship?
Beautiful. We, coming from a big family, my mom raised us, and we were always taught to love each other and respect each other and respect everybody. And that's why we got into careers like we did, firefighting and law enforcement, because we help each other and we help other people. And Beata was that same way. And my wife is a nurse, and those are the people we've always chose to surround ourselves with, are people like us. And I'm sorry, I don't even remember what your original question was.
That's right. So your wife was a nurse and Beata was a nurse.
Yes.
So you and Jack had that in common.
Yes.
Were you there for their wedding, Jack and Beata?
Yes, I was their best man.
And where was that?
That was in Illinois.
In Chicago?
Mm-hmm.
Do you recall what year?
Ooh, now you're really going to tug at me here. No, I don't recall exactly what. Yeah, I think it was like 2004, 2003.
were you there when Maya was born, or around that time?
Not there when she was born, but
I'm gonna skip just a
shortly
little.
after.
Oh no, I'm not. I'm not gonna skip just a little. Give me 1 second.
I loved her.
Okay.
Nicklin,
Yes, especially Kyle.
what do you remember about that?
Kyle loved to fly. I flew back.
Mm,
No, that's kind of a funny story because it was this big, real soft, big teddy bear, and it was too big for them to bring back on the commercial flight. She's a lot like her mom. She's a tough girl, and
they're gonna go through this. Sorry.
In such an ugly situation, he tried to be the strong one and keep Kyle going and keep Beata on track, and just he was struggling.
January 8th, 2017. Does that date have any significance to you?
Yeah, it's my 50th birthday.
Okay, so of course, there's always one that has to go awry. But during his testimony, Robert says that they had a mutual friend basically, and Maya's having these symptoms, and they say, okay, we'll go down to the friend in Mexico, and that person knows this doctor that knows about these treatments, and they're going to stay with the friends. And that's how Maya gets introduced to the treatments with Dr. Kirkpatrick. That's how. So it's not like they were trolling and looking for, crazy treatments or anything like that. It was basically word of mouth through friends who had dealt with things like this that referred them to the doctor. And that doctor didn't just go off on his own. He spoke to the hospital and advised them of the treatment. The treatment puts the hospital puts the port in, all types of things. So it was not this crazy thing that they were doing, according to this guy's testimony. Dr. Barry?
And so I think what people kind of get stuck on is that there was a 50-50 chance of her dying, of her possibly not waking up. The Netflix documentaries showed some videos of her kind of being upset at, I think, as she was going under, and then just how she was when she was coming out of it.
Yeah.
And when your child has a rare illness, sometimes you consider unconventional things that are recommended by your treatment team. And so, like you said, it's not like the parents just came up with this on their own and they were intentionally seeking, because they tried a lot of other things first. And because I think it was Dr. Kirkpatrick that said they tried beta blocker, they tried a lot of the typical things, and it was not helpful for her. And there's a risk when CRPS goes untreated. It's my understanding that it could lead to a very painful, the person can deteriorate. And so as a parent, it was like, do I do this rare thing, or do I see my child suffer? And with the possibility, because I think she got better a lot, afterwards, it worked for a period of time.
It did,
and
yeah.
then she went into remission.
Well put. Thank you for that. So Kyle Kowalski, the son, who's 2 years younger than Maya. So you remember, she's 10 at the time, he's 8. He's going to now testify about his experience of what he perceived was happening at the time that Maya is separated from the family.
At first, were you anybody allowed to see your sister, or was this strike that? When was the first time you remember being able to go see your sister?
I do not remember the exact date, but I do kind of remember the day.
Okay. And tell me about that.
Yes, so I was extremely excited to see Maya because it's the first time I've seen her since she was taken.
Right. And then how was she in the hospital? Besides being excited to see you, but how did she look physically?
She was not doing good.
No?
No.
All right. And did you notice, or did she appear happy or sad about being in there?
She was extremely sad and wanted to come home.
Was she lonely?
Extremely.
And from what you saw, were you able to spend some time here and there with her? When I say time, I mean an hour or so, 2?
Yeah, we were only limited to our time, how long we could be there.
And how long was that?
I do not remember exactly.
Short, long, half a day?
It was short,
Was it less than half a day?
most certainly.
How did the nurses and people around treat y'all?
I do not really have an understanding of how they treated us, but I remember Maya talking about how like some of them did not treat her well, and they were talking behind her back.
Yeah, just hearsay. That's right.
From what you saw, was your sister enjoying her interaction with the nurses or not enjoying it?
Not enjoying it.
All right. And so, how often would you get to come up and see her?
As often as I was able to.
And what was that? Was that once a week, once a month?
I do not remember exactly, but I do know it was as often as I could.
But when we're talking about this period, October, November, December, and into January, then can you give the jury idea? Was this just like once a week or so?
Yeah, it was probably limited to around that time.
And how did that make you feel?
It was extremely sad, especially with the holidays coming up. We extremely missed her and wanted her to be home by the holidays.
Mm.
Was she home then for Halloween?
No,
Was she home for Thanksgiving?
no,
Christmas?
no,
Her birthday is sometime in December, isn't it?
yes,
Was she home for her birthday?
no.
Mm.
Okay.
That's sad.
And so then you obviously recall and just sat through the 911 tape, but you know when your mom passed away, right? We're going to bring you back and talk about that a little later,
Okay.
but I want to skip ahead.
So I'm not playing that 911 tape. It was bothersome to me,
Yeah.
but they played that during the trial, and it's of the husband calling 911 that Beata had, taken her own life.
And I think his observations of her, I think they also have some videos of them together.
Mm-hmm.
And I think she was probably glad to see her brother.
Mm-hmm.
And yet I'm sure it was hard for him to leave her there. And I think what happened is people that did get to see her couldn't communicate how she was doing to mom.
Yeah.
Like that was there were certain
off topic. Yeah. They couldn't do that.
They could not. So anybody that was allowed, because at one point, and I'm sure if dad, if it looked like dad was not going to, because with these types of situations where they're thinking it's one parent and possibly not the other, sometimes they will make people choose. And I have a 6-year-old, and if I was in that situation, they thought there was something with my husband and it's my child, I would, because during the documentary they made it sound weird that he would like he was for his daughter, and I would do the same thing. Like I would 100%, like I would want to be there for my son. And if you watch the documentary, I would wait until after you finish the trial to watch it. But if people do watch it, it does bring up a lot of emotions. Beata recorded a lot. Like there were recorded phone calls, there were notes that she took, because I think it was the nurse part of her that just, in her child's care, she had to document, okay, so they said they were going to do this. Because when your child is in like an ICU, so I remember, because you talked about family members being hospitalized.
Yeah.
Sometimes you have to stay on top of the nurses, because I will never forget, after my mom had a surgery, the night nurse came in and she gave my mom the medicine. And then she came in a little while later, like, and I woke up and she was like, I already gave her meds and she left. I was like, I did not sleep. I was watching that lady the rest of the
Yeah,
night.
absolutely. Absolutely. Oh my God, that would drive me crazy.
And so like sometimes like when you have somebody with an intense illness, like you have to stay on top of
Mhm.
their care. And I
Mhm.
think that's what Beata was trying to do.
Yeah, and it was taken very poorly.
Ed from there and talk about Maya's journey after she got out finally. Did she get out immediately after your mom died, or did it take a while to get her out?
It was not immediately after. It took a little time.
Do you remember how that affected you and your dad not being able to get her out?
Yes, on top of the death of my mom, it was extremely hard.
Okay. And do you remember how she was when she came home?
She was like the worst I've seen her. She was, all her symptoms that she had were extremely intensified.
All right. Did she have?
And so they're trying to tell you, oh, she got better. No, when she came home after her mother died, her symptoms were intensified, according to the brother. So those are, the jury's going to have to decide who and what they believe. That's their contention. Yeah.
At first, were you anybody allowed to see your sister?
Okay, so now we have Jackie Dietert, and she was Maya's teacher. She said it became difficult to communicate with the mom when Maya was in the hospital. So everyone was allowed to communicate with Maya at some point in time, although limited in what they can communicate with her about, but not the mom. And the teacher is going to testify about the impact of that.
Just by me being there and me talking about Maya and what her day was like that time, it really seemed like relief. And I'm sure with Jack, the same. I don't know if they had me, I think they had me on the speakerphone a few times, and a few times I think I was just talking to Beata. And then I don't recall how much longer than Jack could finally go. So then the phone calls one was just with Beata, because she could hear from Jack how Maya was doing.
And over the 3 months that Maya was there, did you continue to provide updates to Beata, or did that become difficult?
Yeah, it became too difficult.
Oh.
Can you explain a little bit to the jury?
Maya was just really desperate to see her. And I just think when I would talk about school and what we did, or if I took her to the craft room, or there was a fall festival one Saturday when I went up there. And I think I kind of knew Jack was seeing her. So Jack was able to give her the head, because she was really sad. She cried. She was desperate when I would then call and talk about me taking Maya to the fall festival. It was too much, and she so desperately wanted to be the one to see Maya that I bet I probably called her for the first 6 weeks, but I think the last month it just became too hard for me to. And we would do little summaries. I would give Maya a little summary of what she was doing for homework each week and what we were working on, and I would forward, I think, those to Beata. But yeah, that became too hard.
Too difficult to keep giving Beata updates.
Yes, because I was the one seeing her instead of her mom.
So sad.
It really is. And so not even that that the courts weren't allowing her to give the updates. Right. It's just she could tell the impact that the updates had on mom.
Yeah. And this also raises another question for me, which is, how does that liability transfer onto the hospital? Because is it the hospital making the decision for mom not to have contact, or is it the courts?
Yeah,
it's the courts.
It's the court, but the court is basing their information off what the hospital's giving them.
Exactly. And
when we're talking about yes. medical neglect, they rely highly. So that's why. So there are some hot topics like emotional abuse, medical neglect, those types of things. And I am very careful about what if I'm working with a family and if I start to get, so I will warn them and I'm like, hey, let me just define for you what this is. And if you're doing these things, I will have to call. And I can document that. And then I can document, because then if that parent continues to react and do those things, then I can clearly say, because it is really hard. Things like medical neglect, they are going to rely on the medical professionals, on those expert witnesses in those types of cases. I've testified in court and I've been very clear about my boundaries and what I can say and what I can't say. And if I'm asked a question and if it's outside of my scope. So if I'm working with a child individually and they're asking, should that child have contact with a non-custodial parent? And I don't work with that parent. I can't give an opinion. Like I have to actively observe that child. And often if I do have an opinion, I give the parents a heads up before, where it's like, hey, based on this information before court, like, I just want to let y'all know this is where I am with this.
Transparency, honesty. Yeah, that's seems to have been allegedly missing in this case. I will say this, that the question, I answer my own question, right? And that is that I don't think you can claim we were only doing what the court told us to do if you are the source of the information and the information was fraud, as is alleged by the plaintiffs. And the plaintiffs are saying, you knew she had actual physical manifestations of this disorder, but you alleged to the court that she did not. You participated in the treatment program until you decided you wanted to take the parents away from the child, but you didn't tell the hospital, the court that. And then the court gives you orders to further harm these people, but you know those orders are based on your fraud that you committed on the court, which is a part of those claims. Why those claims are worded the way in which they are. You're giving treatment for no other reason than to commit a fraud on the plaintiffs in the court, thereby furthering and compounding the abuse and battery that was caused, and injury that was caused to the plaintiffs. So I don't think they can hide behind, the courts made us do it. It's different if they did not give that information to the courts. You know, they gave that information to the courts. They gave that information, and then they give conflicting information to the insurance companies. So I feel like it feels a little icky when you try to say, you know, we have to wash our hands of this because the courts intervened.
Especially when, and I don't know exactly at what point, Dr. Duncan, the psychologist that was on the case, that the family hired. It was odd to me that the psychologist evaluated the whole family. So if I evaluate the parents, I don't evaluate the child, because if I meet the child, I'm going to be biased. Like I can't I can't give a neutral for me personally. So if I evaluate the child, I don't evaluate the parents. If I evaluate the parents, I don't evaluate the child. That's just my own personal thing. But she evaluated the whole family, and mom first, I believe, and determined that mom did not have Munchausen by proxy, including interviewing collateral witnesses. And she diagnosed mom with adjustment disorder, with depression due to the removal
The stress.
the stress of this. That's what, and she did talk about that. She did not see, signs of significant, like that mom when she met with her was not at the point of no more hope. That because she would have followed up with safety planning, that there would have been a different thing that she would have done if that had happened. But I'm surprised the courts ignored that. And still did not allow mom to have face-to-face contact. Mom was able to have some supervised phone calls. And I think it was hard for mom to not ask her, because a lot of how she feels is like the fact that she's in the hospital.
Right. Right.
Like, how was your day? Was like, I was in this bed and they took pictures. I don't know. So there were things that they couldn't talk about. And I think that was really hard for mom.
Yeah. Yeah. That's such valuable information. Thank you, Dr. Berry. And what you said about kind of maybe a wall between evaluating the parents, evaluating the children. I think that probably would have been helpful in this case. Oh, teacher detert though, we're talking a lot about medical professionals not really meeting the standards at least that we as society would like them to you know adhere to, even if it doesn't violate the duty of care. I can't say if it did or not here because that really does have to be decided by the jury. But I just want to shout out this teacher who really the IEP, individualized educational plan she came up with for Maya, the way in which she came to the hospital to teach her. I mean, just above and beyond. Teachers have such limited resources. I really want to shout her out. And I want to shout out our social workers as well, because I work very closely with social workers. You guys work so hard, and most social workers are just so, dedicated to their profession. This one social worker isn't even an example of a fraction of a percentage of social workers and what you guys do out there. So we thank you so much for your hard work. And I just want you to know that you're appreciated. And I work so closely with you guys. I know the hard work that you do. So
Just by me being there and me talking.
then we heard from Dr. Tashana Duncan. And with Dr. Duncan, it's a very long testimony. So please understand, I'm sure I didn't pick out the parts that maybe everybody wants to hear, but let's listen to the part that I did pick out.
And anything else from the plaintiffs?
Not at this time, no.
And you saw that I ruled on the.
Oh, I love that it's not the part that I went to. Oh, there's the hat lady. I see her.
Did you check out that hat? That hat is amazing.
Hold on, let's look at this.
And they think that she might have been able to wear the hat for religious reasons because so the family is
Did they
Jewish.
give you any reason?
No, sorry, Catholic. Sorry, not Jewish. I'm sorry.
They're Catholic.
They're Catholic.
Mhm.
And so, yeah.
I don't know. Is she a nun or something? Nuns don't wear anything that low cut.
Because
Because there's some.
it might just be Florida. You're allowed to wear amazing hats I know Virginia. I've never seen anyone with a hat on in court ever.
Yeah, it can't be Catholicism, but I will say this. Traditionally, right? From my understanding, and this might still be something in the South, courthouses and churches, women are allowed to wear hats and men are not. Wow. So this may be that. So I don't know.
And I'm in Virginia, and I'm pretty South, and I've never seen it, but
you're not South enough, I don't think. I don't think you're in the South part.
I'm in
Virginia.
I'm in Northern.
I'm about to say. Okay, all right. I had no anticipation of listening to her testimony, and I put the wrong timestamp in this. So this is not Dr. Tashana Duncan. I just want to hear what she has to say real quick.
And anything else from the plaintiffs?
Oh, of course.
Not at this time.
Okay, I know what I have to do. Let's do it this way. Boom. Boom. Okay.
Was allegedly allowed or not allowed in the hospital to see Maya?
No, sir.
The witness.
And she said the hospital took her, and I didn't understand any of that.
Ooh, she's a wild card.
Is there an exception, Georgia?
Excited utterance, then existing mental state. You were saying the hospital took her. You can continue.
And I didn't understand what she was talking about at all. I didn't understand that. So I was just sitting there with her to just, help her breathe.
Okay, I understand what happened.
And then Jack came home, and I left to let the two of them be together.
Okay. So that's Our Lady of the Hat.
The following week.
That's Our Lady of the Hat. All right. So here is our doctor. Someone said to boost the audio. I'll do that here. So she evaluated everyone.
Conduct an evaluation of Maya Kowalski in the hospital.
And she evaluated Maya. Let's put it on normal.
That's that privileges.
Turning down within this paragraph here, Findings and impressions. You wrote she was not observed to move her legs or feet for the duration of the meeting. You described this earlier with her feet turning in, correct?
Yes, this was description that was when I was doing the evaluation at the courthouse, not early on. I mean, I saw observed similar
My
behavior
apologies.
at both times.
All right. And then at the courthouse, then the next sentence begins, several small wounds were observed on her face and hands. And then you, Maya denied harming herself and conveying the wounds were lesions. Did you observe these wounds?
I did, and I didn't, these were not visible when I met with her previously, when I interviewed her.
Okay. And you described a second ago that because of the staff privileges issue, she had to be transported to the courthouse by her uncle. So the hospital had to discharge her for that purpose. So the next sentence begins, at the onset of the meeting, Maya apologized for her appearance, indicating her hair was messy. Then you wrote, her hair was not noticeably disheveled. However, it did appear that it needed to be washed. Was it your impression that the hospital had not washed her hair recently?
I could back and refer to my notes, but I visibly remember that it looked like it had not been washed in quite some time. There was a noticeable amount of maybe greasiness. I don't know if that's the appropriate term. And she seemed to be embarrassed about her appearance, when she came in. And of course, I told her, it was fine. That I just wanted to be comfortable because we were going to talk some. I explained the process that we were going to work on that day.
All right. At the bottom of page 7 of the report, you begin to summarize your clinical interview and sentence completion with Maya. And then we'll turn, it's just a header there on page 7. We'll turn to page 8, which continues with the clinical interview. Second paragraph, you wrote about Maya. She did not express any concerns regarding her parents or the care her parents had provided her. She did say she worries about her brother, as she knows he cries about her health. Do you recall any further detail about those statements?
Those were very similar to the statement she had provided me earlier when I met with her, as a collateral to gather information about relationships with her parent and brother. Earlier, she didn't express.
So, Dr. Berry, I like how this Dr. Duncan, described how she asked open-ended questions of Maya to not lead her. Like, my mother is this, my mother is blank, my family is blank. And Maya was just allowed to say, my mother loves me. We like to go on shopping trips. Like, what are your thoughts on that type of forensic interview technique?
So we call it a projective, that there is no right or wrong answer. And it's not, because sometimes you give objective tests where it says, I feel sad, false, sometimes true, mainly true. And there will be different options. And this is, so I give sentence completion as well. And so it starts with the Rorschach, like that was like an old one. That's the ink blot test. But sentence completion is often used with kids and teens, where there's a list of questions and they can put whatever they want. And I've had people put like, I wish I could go home, but it was like because they didn't want to do the evaluation anymore.
Right.
I am hungry.
Yeah.
Do you need a snack? Like, I have snacks, I have water. Or like, just 5 more minutes. Like, we're almost done. But like, it's not asking a direct question, and sometimes you get deeper answers than if you had just asked a specific. And then, like you said, it's not leading. So instead of saying, do you think your mom is harming you? Do you have any concerns about, how your parents manage your health? Instead of asking those specific questions, which she might have asked something like that, this just allows Maya to put whatever she wants.
And then from the attorney perspective, Dr. Berry, when because this is an anticipation of litigation, either in a family court or a civil court, sometimes even a criminal court, what a doctor does when they ask those type of questions is they forestall any cross-examination that says, well, you suggested the answer. I mean, no, I just left it open-ended and Maya just said whatever she wanted. So it does forestall a lot of that cross-examination.
Yeah.
So she does go on to say, as we indicated, that Maya did not receive any cognitive behavioral therapy outside of like 3 or 4 hours in the 3 months that she was there, which is surprising to me. The rebuttal to that on cross-examination was that Maya received physical therapy for what is supposed to be a mental health. Either she's been projected onto, she has Munchausen, or her mother has Munchausen by proxy. What does it mean? What would you say that Maya has if her mother has Munchausen by proxy?
So, so Munchausen's is when the individual is making themselves sick for that attention. Munchausen by proxy, that would be what she would be that's what Maya would be diagnosed with, and that it's the by proxy would be the parent.
Okay.
So, but like the parent is kind of, but sometimes you would say that the child has this fictitious disorder by proxy, like that somebody else is kind of doing this to them. And somebody mentioned in the chat that PT is a treatment for CRPS, and she was getting physical therapy before this. And
so interesting.
And cognitive behavior therapy, because I saw this comment earlier, can be incredibly invalidating, especially for people that have pain, because CBT challenges irrational thoughts. And if you have pain, like she has physical pain, her thoughts about wanting to go home or like loving her family, those were not irrational thoughts. And there were times, I think the hospital might have even prioritized her medical care, because I guess there were times that the counselor went to meet with Maya and she was in physical therapy or she was doing something else. I remember when I did inpatient care, we were only required, and this was on an inpatient unit, we were only required to meet with people from anywhere from like 15 to 20 minutes, maybe an hour. Like there wasn't a lot of intensive counseling happening, because really the goal was to stabilize people medically. So the biggest intervention was medicine. And so on inpatient stays, it's not uncommon for the hospital to only have to provide maybe 15 minutes or 20 minutes to not be providing intensive mental health care.
Interesting. Okay, well that's a good perspective, but I think Trishy's tying it together for us, and that is, so essentially they're giving nearly zero therapy for the diagnosis that they diagnosed her with. Yes.
But that they didn't bill. Like, I wonder if there was any billing for a mental health. Like, I don't know that there was any billing for a mental health condition, because as a medical hospital, you would only be billing that to transfer to inpatient often.
Thank you for that. Okay, so let me see if I can find, and this will be the last, if I can find the rehabilitation of this witness. Hopefully I can. Nope, that's the priest. Hi, priest. It was just ridiculous. They were like, nope, you cannot talk to her about anything to do with her diagnosis. And it's just like, well, he's there to give the rights of the sick and he can't talk. So this is now her cross-examination where they're just like, she got PT.
Ask me questions about her after the collateral interview.
Right. That's not unique to all children's. That's all hospitals.
Yes, it is. In fact, when I called, I knew.
Okay, so past that a bit.
That's correct.
That date sounds correct. I'll report in front of me.
In your evaluation of Maya was at the courthouse.
Past that, I remember that.
Very well, we're here. During your 2 interviews with Maya, she never told you anything that made you suspicious for either abuse or neglect at all children's, correct?
Not that would be reportable under, what we know the statutory definition of abuse or neglect.
Okay. Let me just ask you a couple more questions about your report.
And if I could say something about that.
Go ahead. Yes, that was important. Yes.
It would be common for a 10 or 11-year-old to not understand that what was happening wasn't okay.
Right.
So if I found out that my kid's teacher was was like if I found out something was happening, because some people have asked questions about the essay, and essay is unwanted touch. So it doesn't have, like, there are different, and so I don't believe that, I believe what they were saying, it was the pictures, it was the sitting her on the lap, the hugging, the physical touch that the social worker was giving her that was unwanted. And because she's a child, like she was uncomfortable with it. Which is once again why I said in my treatment, I don't touch
No
children.
touching. Yeah. No touching. Yeah.
Because a child doesn't understand, they might not understand what's okay and what's not okay. And I'm working with some individuals that have had certain boundaries crossed and may
Right.
not understand, healthy boundaries. And so that's where I set mine pretty, just for the safety of the client, and then also myself as well.
So that makes me think of several things. So number one, I'm thinking of recently I watched an episode of Mormon Stories podcast where people were talking about being victims of childhood SA and saying that at the time they didn't know they knew it didn't feel good. I didn't like it, but it wasn't until they became older that they had the language for, no, I was abused. Right.
Yeah. And that's incredibly common. That's very common.
Makes sense. But also is the question is in a way, I mean, and it's just his job, but it's fine. But the question is, if you really think about it logically, disingenuous, because she's evaluating Maya for symptoms of abuse from her parents.
Yes.
She's not going to be inquiring about, now, by the way, is the hospital abusing you? Has anyone at the hospital touched you in a way that you don't like? So how is a 10 or 11-year-old going to know to say, the social worker put me on her lap and said she's going to be my mommy, and then they pulled up my pants and my shirt and they took pictures of me and I didn't like it? Because all she knows is that she's at the hospital and she's getting treatment. She doesn't know that, like, what they should and should not be doing. So it just doesn't feel like it's very it's like real life. It doesn't feel like it's a very informative question. And it doesn't feel like it's dispositive of whether or not the child self-reported it at the time. We as adults looking at it from the outside, if the actions actually took place, we get to determine, the court of public opinion and the actual jury, whether or not that constituted battery and abuse. So, all right. Here we are. So many tabs.
After the doctor spoke with her about it. I just don't have it in front of me. I mean, I don't want to misstate something.
No, I'm happy to.
That's still a cross. I think they're gonna
to perform the neuropsychological.
Okay, here we go.
I'd like the witness, anyway, object to the lead.
Okay, sustained on leading.
Are you aware how Dr. Lewis was selected to perform the neuropsychological evaluation at the hospital?
I recall reading in some of the information, I believe it may have been in his report, that I'm in front of me, that the referral, Dr. Smith made a referral.
Right.
I am aware of that.
And so several statements were put on the screen about what Maya allegedly said to Dr. Lewis. Are you aware that Maya disputes Dr. Lewis's reporting?
She disputed some of that specific reporting to me, so I'm aware of some of that.
And earlier you testified, I think, on my questions that, and perhaps on counsel's questions, that you, subject to request from the hospital, provided your raw testing data and the totality of your file for these psychological evaluations, did you not?
It was for Maya's, I believe, the raw test data. I believe they had a hearing in.
All right. So Dr. Lewis makes these statements, which Maya disputes. Are you aware that when a request was made to Dr. Lewis for his raw testing data and notes, he claimed to have lost them?
Object to the leading.
I'm not aware
I'm
of
going to
any.
overrule that one.
I'm not aware of any records requests other than what was made in my office.
So have you ever seen the notes or a recording of the?
So I guess this is the doctor that's saying opposite of what she's saying.
Yeah, so the hospital did a neuropsychological at the hospital that was requested by Dr. Smith. And it was someone Dr. Smith picked. So with Dr. Smith picking this person, the doctor likely said, this is what we're thinking. We need you to do testing to see if this is what's going on, which plants confirmation bias. So
And then
when I
also he's not providing his like the data that he used to reach his conclusion, so she can't look at that and make her own individual assessment of how sound his technique was in making his decision. Is that right?
yeah.
Okay.
Interview or raw testing data from Dr. Lewis.
I've only seen his written product, the report.
And during this interview, we've established Maya was on multiple medications from the hospital.
Based on the information and the record that she'd taken medication the day before.
All right. Now, with regards to 4 hours
Oh, here we
of
go.
cognitive behavioral therapy,
Yes. Come on.
your comments during my questions were limited to the limited cognitive behavioral therapy that the hospital provided during that 3.5 month span, right?
Mhm.
Yes.
And that's what led you to characterize the hospitalization as warehousing this girl.
Yes, and the fact that my understanding is that Dr. Lewis recommended the neurological consult, and throughout the entire process, everybody said a neurologist would be the one to rule out the diagnosis or confirm that the medical doctors were telling me I'm not qualified to do that. And the information provided to me is that that never happened.
What?
Yeah, the actual so she met with a neuropsychologist, which is different from a neurologist.
Of course.
And that would be the person that would diagnose CRP.
What? So they never got a confirmatory diagnosis from a neurologist on this disorder that they're saying she doesn't have? The person who would be qualified to make or rule out that diagnosis?
Which I would think would be the standard of care.
Isn't that what we're here for? Legally speaking, my bow is falling down. Legally speaking, we are here for the standard of care. That's what this is all about. So you're going to treat this child with physical therapy when you're saying it's mental. You're going to give her physical therapy. You're going to give her ketamine. You're going to say that it is that disorder to the insurance company. You're going to tell the court, though, that her mother is crazy, but you never, ever get a neurologist to rule it in or out, CRPC, or however it is that you say it. That, to me, does not sound right. Dr. Duncan, who's testifying right now, for those of you who don't know, is a psychologist, 20 plus years of experience.
I think that right there, and I didn't, going into it, I didn't know.
Mm-hmm.
And because she wasn't asked that on, because this is redirect, right?
This is redirect. She wasn't asked this on direct. And they opened the door to her testifying about it because they start asking her about physical therapy. Now she can talk about pretty much unlimited amounts of treatment that Maya received because they're inquiring about something she never even opined on. She didn't opine on physical therapy. That has nothing to do with her practice area. But if you're talking about differential diagnosis, right? You would think you would need to rule in and out the physical and mental health manifestations of the disorders that you're talking about.
So if there is a Munchausen by proxy case, you work very closely with the medical team because you have to rule out, is there a legit medical concern?
Yeah.
You have to rule that out. And I can tell you as a parent, so it's often a parent's worst nightmare that you take your kid to the hospital and God forbid somebody think that you're doing something or that something's wrong with you. I will tell my kiddo, I think he was like 3 or 4 months old. Mm-hmm. He developed like a fake wheeze. And I recorded it because like he wanted, so like he would like wheeze, but like it wasn't, he was fine. And the doctor was like, just don't react to it. If he does it, like just let it go. But in the back of my mind, I was like, God forbid somebody make a false claim that can impact my livelihood.
That's
like
right.
I wouldn't be able to. So a big part of my practice is working with kids and teens and families. And so, because some people I've seen, and not necessarily in the comments here, but people have talked about like just being afraid of, somebody making, false claims. Reports.
Yeah.
And I'm just so glad that they had so much documentation of all of this along the way. Because from where I am so far, the hospital looks pretty.
This is a doctor speaking. Oh, some people are saying, so just joining. What is Dr. Berry a doctor in? Could you just tell them one more time, please? Thank you.
So I am a licensed clinical psychologist. So I do psychological testing and therapy. And I've consulted on custody cases and on CPS and certain. So I don't do forensic evaluations, but I will sometimes do a general psych if they're concerned about someone's mental health.
Okay, great. Thank you. And our Dr. Duncan here is doing a forensic evaluation, and she's opining in her medical opinion on what actually the parties were and were not suffering from, and the deficits in the evaluations conducted by the hospitals or defendant side of things.
And so you were confronted.
I have to go back just a little bit because that was just so big and it's kind of lost. They didn't do a neurological evaluation assessment with the doctor, and they had her there for 3 months.
Would be the one to rule out the diagnosis or confirm that the medical doctors were telling me I'm not qualified to do that. And the information provided to me is that that never happened.
And so you were confronted a minute ago with a bunch of physical therapy and occupational therapy records. You never expressed any opinion on the adequacy of occupational therapy or physical therapy at the hospital, did you?
No.
And in everything they presented you, did they confront you in any way with any additional cognitive behavioral therapy record to dispute the 4-hour figure that you tallied?
No, like I just said, the information I have was a duplicate of what I'd previously gotten that y'all provided me regarding to the psychological and psychiatry notes.
The problem that you were pointing out, if I understood you correctly, was that they were alleging that Maya had a psychological disorder. Meanwhile, they provided 4 hours of psychological therapy over 3.5 months.
Mrs. Sandy asked the answer.
What is the problem with alleging that a 10-year-old girl has a psychological disorder
without providing,
but not providing therapy, if there is a problem with that?
Well, I think at a minimum, even though I didn't evaluate Maya early on, at a minimum, she was on a psychotherapy regimen of getting it weekly. So I would have expected them at least to start with that. And then if she made significant improvements, they might, titrate the therapy, go to both biweekly or less frequently. And I think that
she's saying that, and this is what Dr. Berry said at the outset, Maya was getting mental health treatment in the care of her parents.
Yes.
Because they disrupted that.
Because chronic pain has an impact on your mental health. So I work with a lot of people that have chronic debilitating, because before she went to the hospital, I do believe, because they bring up, I think, the fact that she was already on homebound instruction. So she did have some physical things that did impact her ability to attend school in person. And I've worked with people that were on homebound and for various reasons, and being able to look at, they didn't even consult with that therapist. I don't know. I haven't heard that they consulted.
I haven't heard that they did. I haven't heard
because that would have been, if you think she has a psychological condition, I would have consulted, like, hey, have you ever had any concerns? Has there any, because that person would have reported to CPS before them if at any point she felt that mom was impacting her reporting.
Is it your opinion that that is inside or outside the standard of care?
So not providing her therapy?
Mm-hmm.
So that would be outside of the standard. If she's getting weekly outpatient therapy and you think she has a psychological condition, I agree with this doctor that you would at least do or allow her outpatient therapist to possibly meet with her. But you can't bill outpatient while they're inpatient. So that's why inpatient has to do everything, because while they're inpatient, insurance is only going to pay for things that can happen within within the hospital.
Okay.
Even whether her issues were psychological exclusively, as some people are taking the position of, or whether it was a medical problem and there were some psychological problems interrelated, secondary, I think certainly The professionals that worked with her in the mental health field, Dr. Katzenstein, was even seeing this child was very distressed over a lot of the circumstances.
Understandably.
And I think that there was a lot of documentation where, I didn't do the PT, that she got PT because they would go to get psychotherapy and she would be gone, but then there was no makeup session in the hospital.
All right, last area.
This is a
There
good
was
redirect.
discussion about these attempts to transfer Maya Kowalski to Nemours.
And the defense is saying, and I think it's a good point, that there were attempts to take her to another hospital. If you think we're so terrible, basically we could have transferred her somewhere else. So let's hear about that.
Are you aware of the transfer diagnosis that the hospital actually tried to transfer her under to Nemours?
I think as I said earlier, I don't recall the specifics of it. It's been a long time. I just knew that there was some dispute on whether it was going to be an appropriate placement based on, I think that there were some concerns about parents had on whether they could do medical. It wasn't clear to me. I just knew the child never got moved. It wasn't clear to me all the dynamics between all children's, maybe the dependency action and the parents. I wasn't privy to all that.
And so you weren't aware that Johns Hopkins, All Children's Hospital, was trying to force a transfer.
I object to the foundation.
The foundation is she doesn't. He's right.
She's not aware, and now he's about to give her a leading question.
Yeah, so that he can testify. He's trying to testify.
Were you aware of Beata Kowalski's sensitivity to having Maya Kowalski diagnosed with a psychiatric or psychological disorder?
I was aware from my work with Beata that she was concerned that the medical issues, that she had a real medical problem that was being dismissed and labeled strictly psychological. I did not get the impression in my evaluation of her that she was against any type of therapy or intervention. In fact, her therapist reported to me, and it was in the notes, that her and Maya's dad consistently brought Maya to therapy sessions for therapy after having the illness diagnosed.
All right, so we know that Dr. Katzenstein believed that this child had a physical condition, right?
So she told me.
All right, assume for the purposes of this question that Johns Hopkins All Children's Hospital is trying to transfer Maya Kowalski, not with a physical diagnosis, but with a psychiatric.
So you usually can't ask a hypothetical question of a witness, but she's an expert witness, so he can do that. So because he can ask her to assume certain things because she's an expert.
Diagnosis. Knowing what you know about Beata Kowalski, would it make sense for her to resist those efforts?
Objection to the speculation.
She's an expert. She's an expert. I overruled that.
Are you aware of a phone call that was recorded?
He can stop these questions because he's made his point and he can argue these things to the jury. He doesn't need her to answer them. This is just a legal point, like a little technical point.
Regarding this dispute over the discharge diagnosis to Nemours.
I don't believe that I ever listened to any phone call or was provided information on that. Like I said, I got limited information because my work was pretty focused on what I was doing as part of. They had a lot of hearings I wasn't involved in.
This makes her more trustworthy. She won't go too far and try to opine on things that she doesn't know about. And I appreciate that about her. And I feel like her attorney, the plaintiff's attorney, could have stopped at the whole, they never took her to cognitive behavioral therapy or got a neurologist. They weren't really trying to rule anything in or out. They were just like, we don't like Beata. That's what it really comes down to. That's what it sounds like to me. Dr. Berry?
No, but that's really, really so, because I think the family is saying that this hospital had a vendetta against the mom and wanted to make sure that she didn't see her again.
Yeah.
Like that's what the family is pretty much saying.
Yeah.
Because I think a parent advocate did try to tell Beata, like, just say you'll do it. Like, just get your child back and then do whatever you want to do.
Right.
Like, that's what they were trying. But Beata wouldn't. She was like, no. And then there have been other allegations from other families about some of Dr. Smith's actions, and that's
Mhm.
covered in the Netflix documentary.
Okay. Right. Well, we'll have to see more about Dr. Smith as the trial plays out. Some of you guys did say that the jurors had interesting questions for this witness. I didn't hear them, and I'll try to conclude with seeing if I can pick up a couple of them, but I'll give it a quick try, but if I can't, I'll move on.
And I think one of them was specifically about cognitive behavior therapy and
Mhm.
maybe the treatment of like CRP, or like if you did think it was a mental health, what would be recommended?
That's a good question. All right, let's see.
To somebody.
Plaintiffs, any further follow-up questions?
In this case, I believe that all of the collaterals, so I would have anticipated getting more than 3 hours therapy past the initial.
These are the questions, I think.
Yeah.
How many hours?
Yep. Okay, great. I know she's my thumbnail, but I don't like how they keep the camera on her for so long. Give her a little bit of space to feel her feelings. This is me also processing the fact that I made her the thumbnail.
But I think the family wants her to be the face of this. Does that make
Mhm.
sense? So I would have
Yeah.
so like with the Ruby Frankie case, I tried to I don't show
Same.
the children.
Mhm.
But for this case, the family has intentionally made
Mhm.
this about Maya and
Mhm.
about taking care of Maya. And
Mhm.
so that's why I was okay with it.
Okay. I am clearly processing things in real time. Okay, I think we're getting to the juror questions now.
And thanks, Matt, for sharing my link. I appreciate it.
Thank you, Matt. Juror questions. It looks like we do not have this in my state. We do not let the jurors.
I don't think Virginia either. I don't think
Yeah.
they get to ask questions.
But I think I
Pretty
kind of
cool.
like it.
It's pretty
Yeah.
cool. I know they did it in North Carolina
Yeah,
for
members of the
South
jury, I'm
Carolina,
going to go ahead and
Murdoch.
ask all
South
the
Carolina.
questions. Just as a reminder, when we're having this, if you want to stand up and stretch, you are more than welcome. In fact, you're always welcome to stand and stretch.
Means
even
they're
if
getting
we're
tired.
having questions. Anything that you want to do, that's fine.
Anything.
Okay. Well, I shouldn't say that.
Not anything. Anything you want to do, Judge.
Transcript will say that there were absolutely no laughs with that one. Okay, Dr. Duncan, how many hours is appropriate for psych treatment without resolving the medical diagnosis?
You might need to block her. I don't know.
Yeah, hold on 1 second. Let me take care of that.
So I didn't evaluate it early on,
dang.
but
What's so funny is that like okay, so we have mods, right? I love you guys.
Boost engagement. Like, I don't know if people understand that.
No, it's just like all you're doing is just adding adding comments. Thank you. Like 10 more people joined when you did that. And also add engagement, but you give me a laugh. I don't want to like address what's going on like on the stream because I don't want to give you more attention than you need. But oh my God, that is so funny. Like, what is wrong with you?
I know. So, and so getting on social media, like, and protecting my own mental health, like, because I saw another person I follow, I'm mutuals with them, and they respond to negative comments, and I'm just like, no, like, I just can't.
I mean, I used to, and like, I guess what it was is like, just, I have a spirit of arguments, right? It's just how I'm built, right? Also, when people do my job, so I'm like, well, no, that's not true. Why would you say such a thing? And nowadays it's just like, oh my God, what is wrong with you?
So my rule is be kind if you want to provide feedback. And like, if it's like feedback, then that's different.
Yeah.
But if you're just being, no. So.
So I kind of want to go back and listen to the jury's question. And I guess I should be mad because this is a very serious video. Like, we are talking about self-harm and child abuse. Chill out. Pick another video to do that with. Really, like, come back tomorrow. We're going to be talking about foolishness tomorrow, and do it on that video. You're more than welcome.
Having questions, anything that you want to do.
Okay. I just want to hear the question again.
Transcript will say that there were absolutely no laughs with that one.
This video doesn't have
Okay,
closed captioning.
Dr. Duncan, how many hours is appropriate for psych treatment without resolving the medical diagnosis?
I evaluated mine, but it was at the latter end, so I didn't evaluate it early on. But I would have anticipated they would have started with at least an hour minimum of therapy, because that's what her
What she
prior
was getting.
person that was seeing her was providing. So I would have think at that assessment, then they could determine if they need to increase or decrease their frequency. But I was just shocked for the drastic drop, even overall, because she was getting about at least an hour a week before, was my understanding.
So this is like, they're basically asking her, what is the standard of care? That's what it sounds like to me. What is the standard of care, doctor? And she's just like, it's hard to pinpoint because it dropped off so drastically, but at least keeping her with what she had before. Uh-oh. All right.
Okay, the next question from the jury. In the absence of medical diagnosis, in the light of the patient treatment, would you or of the PT, physical therapy treatment, would you still use the word warehouse in reference to all children's?
Can you read that one more time?
Yes, ma'am. I'm sorry, I misread
No,
it.
you did a good job. Just me, I'm tired.
In the absence of medical diagnosis, in the light of the physical therapy treatment, would you still use the word warehouse in reference to all children's hospital?
That's a good question.
I used that term because I did not think they were following up on the neurological home, so I had to figure out what was going on medically with her. And also, they were not providing, there was a lot of suggestion that it was just strictly psychological in nature. And so I would have anticipated getting more than 3 hours therapy past the initial assessment. As far as PT, I'm not a medical doctor, but in my experience, people that get PT, I've worked in inpatient rehab, they usually have a medical diagnosis to get that. So
The next question from the jury. Can collateral interviews be performed with individuals that you deem necessary or only with individuals that are provided by your client?
I do both as part of my evaluation. So, they did in this case, like list the teachers, but it's not uncommon for people not to list people. And so in my work, just not in this case, I often ask to speak to individuals that may be not listed that I know are relevant. Obviously, the people can choose to participate or not. The collateral can, but in this case, I believe that all of the collaterals, the majority of them, the family did provide me as far as like the professionals and so forth. But I don't recall anybody like specifically say, "Can you call Dr. Katzenstein?" And I made the effort to call her.
So what she's saying is she made the effort to call people outside of what was just suggested by the family, which is good. Go ahead, Dr. Berry.
Because the defense brought up the fact that she was a paid expert by the family. So the defense brought that up, that this wasn't a court-ordered evaluator, that this was someone that the family hired. But that's common. So this was family court, or at least in Virginia. If the court orders an evaluation, in Virginia, the family is often able to choose who they work with. It doesn't always have to be a somebody that they're referred to by the court, except for in some situations if they need to get an expert.
These are some really smart questions, Dr. Berry. I am really impressed by the questions that they're asking, and her answers are not evasive. They're direct and to the point, and I think that's really helpful. And like she concedes things that she needs to concede, and then she, pushes the point she's trying to make in other areas. And so overall, the impression that I'm getting is that the jury is at least concerned or really interested in knowing, is what the hospital doing, is that care in light of the information that they had? And she's reiterating, well, they could have gotten a diagnosis and they didn't.
And
No shade. Go
even
ahead.
her redirect of,
Mhm.
in my experience, working in a health unit,
Mhm.
that when PT is ordered, there's normally a medical
Yeah.
diagnosis. Like she
That was a
threw
good
that in
point.
there.
That was a good point. No, because she was like, they're giving PT, and she's like, yeah, but there's no medical diagnosis, so that's not normal. And she said it very nicely, and I trust this jury to pick up on it because the jury seems to be very,
So
during the. Go ahead.
she didn't come off as overly on the family side. Does that make sense? Like if she had been
No.
presented with something, so to me, Dr. Lewis from the Letitia Stout case, like
Mhm.
sometimes I've watched and there seems to be a clear, like,
Mhm.
like it doesn't come off very well.
Yeah. Mhm.
But in this case, to me, she seemed extremely professional and
Mhm.
she was giving her professional opinion. Because so if somebody hires me to do an evaluation, they're not paying for my, like, so I'm going to find what I find.
Mhm.
Now, they can
Mhm.
choose not, because often they see it, but like they can choose to not use it.
Yeah, they'll just not
But,
call you. Yeah, exactly. They won't.
but
They'll talk to you and they're like, okay, no report, thanks. And then they won't call you as a witness.
nope.
So I will say this. Juries get bashed sometimes when people don't agree with their decisions, but I, by and large, trust juries and the jury system. I really think that they're smarter than people give them credit for, especially when you get a group of them together, just everyone bringing their life experience to bear. And I think that these questions are just, they're going to direct the defense and the plaintiff to fashion their case in a certain way because they're going to be like, oh, this is what they're thinking about, right? And so far, I don't think it's a slam dunk for either side in this case. I really do not. I still think that the defense has a good argument, that we were following the standard of care and they were acting really weird. And wouldn't you think they were acting weird too? Kind of low key, that's what the argument is. Like, anybody would think that they're acting weird and we're not quite sure what's going on here. So we're being extremely cautious and we're trying to protect Maya just like the parents are. So that's the defense perspective. And it's not blown away at this point. Their perspective is not ridiculous at this point. I'll say that. I'm tending to lean more towards the plaintiff, but that could just be because of bias, so.
And so far we've seen the plaintiff's case.
Mhm.
And so
That's right. Good point. Excellent point. The defense's case has not been presented yet, and I'm sure they will put on a case. So, yeah. All right, let's get to these super chats. Katie Brown, welcome to the Lawyer Chicklets. Matt has been a member for 26 months. Thank you so much, Matt. You've been so just valuable during this stream. Thank you. I've seen all the work you've been putting in as a mod and helping us all out, putting Dr. Berry's channel in the comment section. Thank you. Thanks for covering this. CRPS is what I have. Oh, Matt, we've talked plenty of times. I didn't know that's what you had. I didn't know you had a chronic disorder. Thank you so much for sharing that with us. And I did see your insights in the chat, so thank you for that. Majira? I'm going with Majira. I'm sorry if that's wrong. Left Rob's stream viewing on the trial to come watch yours. Really interested in the psychological aspects of this case. Thank you. But then go back and watch Rob's because he always has great content. River Shoal is a new member. Welcome back to the Lawyer Chicklets, River. Tori, welcome to the Lawyer Chicklets. Suba, nice to see you, Suba. Rather have sepsis or... Oh, you don't want to go to the ER. That's what you're saying. I know a lot of people are very scared of doctors, and I hate that because we need doctors. Equality, thank you for the super chat. I've been struggling not to be biased. Poor Maya. Same. Absolute same. We're trying so hard here. Trust me. Beverly D, welcome to the Lawyer Chicklets. Sandy has been a member for 24 months. Thank you so much. That's 2 years. Wow, you're awesome. Thank you. Anna Catherine Sandgikowski. Welcome to the Lawyer Chicklets. I tried. Destiny Salazar, thank you for the super chat. Didn't the defense admit in opening statement that the hospital got more money billing for a CPRS diagnosis?
I didn't see that part.
I didn't see that part either, but I don't think they're necessarily dismissing or like a lot of the plaintiff's claims are not untruths, the defense is just saying, no, it's for another reason. Like, we put the commode far away from her, not to force her to get up so that we could catch her being able to walk when she said she couldn't. We put it far away from her for other reasons, that are totally reasonable. So that's a lot of what their defense is that we did things for good reasons, not for bad reasons. And I'll say this as a professional, sometimes as an attorney, clients will interpret things that I do as like, oh my God, you're trying to throw me under the bus. You're trying to do this bad thing to me. And I'm like, oh, no. Here's why I'm doing this. This. That's why bedside manner is really important. This. And there's this law that mandates that I do that. Like, a really easy example is I tell the client about the plea offer and they're like, you're trying to force me to take a plea. And it's like, no, legally speaking, I have to tell you what this plea offer is. I cannot keep a plea offer from you. That is illegal. That is unethical. Right. And so sometimes we as professionals do things and clients or patients will take it as, oh my God, you hate me. You're trying to screw over my life. And it's like, no, I'm just trying to like follow my ethical obligation. So I do have some sympathy for that. And like, I don't know what these doctors and people were feeling on the inside and what they were actually genuinely believing versus like how it got projected out to the family. So I try to keep that in mind. So Matt Bond said, I signed a care plan saying I know the risk of the meds I'm on and the hospital aren't responsible for any issues that arise. Yeah. And I guess like on one hand, if Maya was an adult, a lot of this stuff would not have happened because she could have just had informed consent.
They might have thought, so there is Munchausen, which is that they think the individual is faking their symptoms. Does that make sense?
So they could have thought that she had Munchausen. Yeah. They kind of are already accusing her of that because they're saying like, allegedly Maya's crazy. Let's film her.
And that was the conversion disorder, like that was briefly mentioned, and that's like a different somatic condition where, because the Munchausen is specifically for attention. Conversion disorder is someone who legit believes that they have a condition, that medical. So the hard thing with the medical, and I think I said it before, but I'll say it again, that when they can't find a diagnosis, the first thing is normally mental health. When sometimes they might need to go to a special, like their mental health might not be it.
Yeah.
It might not be a mental health condition.
Yeah, absolutely. I mean, again, I'll bring it back to the situation with my mom. I mean, we're in the hospital. I know something's wrong. My whole family knows something's wrong. We're like, no, this is not. And they are telling us that, no, she's at baseline, but she has developed dementia just out of nowhere, just advanced dementia, didn't have dementia before. Out of nowhere, that's what all these symptoms are. And it's literally like she's having multiple seizures back to back. What are you talking about? That's not what's happening. What are you talking about? That is not what's happening here. But they went to these physical manifestations of secondary stroke is just out of nowhere advanced dementia. And that's very frustrating because that was easier. That was easier than just having to deal with the very real difficulty of a stroke on top of another stroke. Eileen has been a member for 5 months and says, sounds like torture, not treatment. I hope for justice. We'll see what the evidence shows. We really, really will. Oh. Beach Lady, thank you. Medical coder and biller here. Ooh, great. Thank you. I think my cousin does that. Inpatient stays, hospitals can legally bill for suspected condition, but not yet confirmed. But it looks the same on the bill regardless. How could this impact this case?
But even if they suspected it, but they bill, because they're telling the court that it was mom.
Yeah, they're telling the court.
So
that's the additional thing. Yeah, like I feel like the fraud isn't even so much in the billing, even though it is a little bit. The fraud is in telling the courts she definitely does not have this thing, but here's evidence of us equivocating at least that she has it. Here's evidence of us receiving evidence from other medical professionals that she has it, and we don't tell the court that.
And we don't do the neurological to confirm or rule it out.
Why not? I just don't get it. Why? Equality. Thank you for the super chat. When my daughter was 3, someone called CPS because she has Mongolian spots. I
Yeah,
was
so
so
my
upset.
my kid had those. So it's
What is
often in
that?
darker skinned babies. And
Okay.
I took pictures of them because
Mhm.
Mongolian, so I intentionally, so my child was born with Mongolian spots. It's really common in darker
Mhm.
skin. So people of African descent,
Mhm.
and it's these dark pigments. So my
Mhm.
child was born lighter than what he is now. And even
Mhm.
to this day, he still has dark spots on his back that look like bruises, but
Mhm.
it's the Mongolian spots. And so,
Oh.
yeah, they're just little dark, but they're born. It's like a birthmark, but it
Mhm.
looks, if somebody didn't know, they could think that you were harming
Yeah.
your. And so I have it documented
Mhm.
in his medical chart.
Mhm.
So from the time he was born to and I think I documented it for the daycare as well. They were like, any
Mhm.
medical conditions, I put Mongolian spots for, because
Mhm.
the daycare would be changing him. So
Yeah.
just in case, because he had large ones in
Mhm.
areas where he would be
It could be
changed.
a bruise or something.
Yeah.
Can I confess something? These cases terrify me so much. They terrify me so much because I'm afraid that, like, because I'm always the one that, like, I'm not going to see something crazy with kids and just ignore it. I'm not doing that. So now I'm just like, well, am I looking at bruises or Mongolian spots? Is this mom crazy, or is there some really rare disorder that this kid has? When should you report stuff? Like, can you talk a little bit to that? Because there's a little bit of, I think some people that are more critical of the case understand, which you should be.
Yeah.
You should be using your brain at all parts and looking at everything critically. But some of the vibe I'm getting from some of the comments is just like, well, that's kind of suspicious. Like, shouldn't I report that? And that's kind of
And
why some of those charges got dropped too. So anyway, so what are your thoughts?
And a difficult thing is that often with Munchausen, by proxy specifically, sometimes the parent has a medical background. So they
Yeah.
have medical knowledge. And so,
Oh.
yeah, like that's a difficult part,
Oh.
that that can sometimes be the profile for an individual
Oh.
that does have that actual diagnosis. And so that's where I do have some sympathy for the hospital, but
Mhm.
I've seen other cases like this, that
Mhm.
when the child did not have contact with the parent that was
Mhm.
making them sick, that the
Mhm.
child got drastically better very fast, to the point of
Mhm.
me being able to stop medication, to the point of like improving physically and not needing to be on homebound anymore. To me, Maya's condition did not improve because she wasn't discharged
Right.
after not having contact. Like, she still had medical issues, and
In the
like she
hospital.
and not like, because in like you see her feet turn in and
Mhm.
all of these other things.
Yeah, and I don't know, that turned in feet thing looked really scary to me. That looked real to me. I don't know. But I'm not a doctor, so what do I know? Israel says maternal versus survival. That was in the opening statement. That was well stated. And that really stuck with me. And I don't know. I could no, I'm going to be careful. I'm not going to go there with what the mom was thinking before she took the action she took, because that's a slippery slope. But
Yeah.
um, yeah, I'll just leave it at that. But yeah, that was a very poignant point. Um, Charlotte says, I bought the Netflix version 100% at first. The more I learned, the more my mind changed. Well,
Okay.
Charlotte, that's good. I mean, that's good if you're thinking critically. I think that's
Yeah.
okay, And I didn't get through the whole entire documentary. I didn't finish it, but it is slanted, it's
Yes.
definitely slanted to one side. So
And to me, it made the social worker and Dr. Smith, like that. That
mhm,
was that seemed to be the focus of that one,
mhm,
and they are not the main focus
of
of
the trial.
the trial.
Because they settled.
Yeah.
I think that movie probably made them be like, oh, let's get out of here. They settled for 2 point something million.
And so the doctor has has insurance,
Mhm,
and so the
yeah,
hospital has the policy as well.
that's right.
Um, it doesn't cover. It's not. They don't plan to do these types, but like it
Mhm.
likely they
It's
probably
gonna
have
help
large
something.
incident. Yeah,
Mhm. It's gonna help
but
something. Yeah.
yeah.
Mhm. So Barbara wants to know, why didn't DCFS or the hospital arrange for supervised visits? What they did to Maya was pure torture. Thank you for covering this hot topic, Natalie. Thank you. Thank you.
And so the hospital, DCFS did allow at some point, they did allow mom to have some phone contact, very brief, and the social worker that mom did not like. So it was always supervised by, what was her name? I'm bad with names.
B.
Yes,
Mhm.
it was always
Miss
supervised by her, which was a trigger because I think mom did not feel safe with her daughter being with her, or for that to be the individual that was supervising.
Seems like mom was
And
right.
dad was allowed to have in-person visits, and brother was allowed, but it wasn't like, it didn't, I think it was, I don't know if it was weekly, because that can be common for supervised visits. Sometimes it is weekly. And it was a court order that mom wasn't able to, based on.
Yeah, and so I guess you can't put that on the hospital. Well, directly, but indirectly you can, if you say they lied to the courts in order to get that ruling, in order to force a particular action. So Suba says, I think the medical industry isn't for people who genuinely want to do what's right for the health of patients. I feel like I'm in the wrong industry. So sounds like you're in the medical industry. I'm sorry that you feel that way, but that's continue to do the best that you can to help individuals, and you will be the bright light in the system. But systems fail, right? They do. Like, I work within the criminal justice system. Oh my God. The drama. There's always something going wrong in the criminal justice system, but it doesn't mean that you just stop participating, because people need your help. So I feel you. Christina B, this is one of your super chats, Dr. Berry. Because you are awesome, Dr. Berry. Thank you. Thank you, Christina B. Tiffany says, oh my God, I actually have something similar. My tongue is on fire every day. It's called burning mouth syndrome, and it was triggered when I found out my dad had ALS. It's a small community of us on Facebook. Wow. I'm so sorry. That sounds horrible. Does it affect the way food tastes? I wonder. Gally May, thank you for the super chat. Love your channel. Thank you. Your matter of fact, basic take on such difficult subjects is so refreshing. Thank you. Oh, this is one of yours, Dr. Berry.
Oh, thank you.
Thank you is to you. Yes. Let me make sure that I didn't miss any more that were to you. Okay. No, I think okay. Because I was trying to remind myself to get it right. Like, make sure you let Dr. Berry know.
And it's getting late. We're all getting.
I'm getting a little punch drunk. Yeah. Okay. Miss M, welcome to the Lawyer Chicklets. Ace Moonshot, this is one of Dr. Berry's. She's giving you they have given you a super sticker. This is also one of Dr. Berry's from Night Owl. Thank you, Night Owl. Thank you for covering Maya's case. I'm so glad I found your channel. # Team Maya. Meso Karev, thank you for the super chat. Sorry, Natalie, but LawTube ends tonight when your coverage ends, at least for me. There can only be one. You guys are so silly. Dr. Ashley Vigil Otero. Thank you very much, Dr. Ashley, for the super chat. Maybe you went over this. You can have both CPS and medical abuse, CRPS and medical abuse. This is true. You can have an actual medical condition and then seek excessive treatment or exaggerate. You could also have conversion and medical abuse. Not even something that I thought to address. Such a good point. Thank you. Dr. Berry, do you want to speak to that?
And I think that's where they're going to bring up the ketamine. And that possibly the ketamine might have been what caused the initial complaint, like the stomach pain, the cramping and everything. Because I think the doctor that was prescribing it, because I saw a part of the deposition, but it's on the Netflix series, not yet in court. But because they were directly asked, what are some of the side effects of ketamine, and can stomach pain be one of them? And so I think that's what the hospital is going to say, and we'll see where this goes.
Yeah, that can be. That's a good point. It's a good point. It's a lot, and there could be people out there in the jury that are just like, that's too much ketamine for a 10-year-old, a 9-year-old, so that could be out there. Christina B says, you're both awesome. Thank you so much, Christina B. And thank you to all of you lovely Lawyer Chicklets and Dr. Berry's, right?
A crew, psych crew.
The psych crew.
I almost don't even know.
Okay, you guys be well. Thank you so much. Give me 1 second, Dr. Barry. Don't go away. I'm just going to sign us out here. And good night, everybody. Bye. Oh, subscribe to Dr. Barry. Bye.